All right, committee, let's go ahead and get started here. Oh, there we go. All right. Thanks, everybody, for making it back in today. Thanks. Let's see. We're going to open with occupational licenses in Kansas. Eric Adele has put together a presentation for us that I believe you emailed out everything last night, right? Thanks.
Yes, that's right. Thank you, Mr. Chairman and members of the committee. So for the morning, we're going to be talking about occupational licensure today. And then in the afternoon, talking more about regulations more generally. But I wanted to give you kind of a brief overview. So I'm going to be presenting two things kind of back to back. The first is an overview of occupational licensure in Kansas. And the second is going to be an overview of interstate licensure compacts that have been enacted in Kansas. So in front of you, you have a memo with KLRD on it. It's titled Occupational Licensing in Kansas. So that's kind of what I'm going to be walking through. And if you don't already know, occupational licensing is just a system for granting individuals permission to practice a particular kind of business activity. There are other similar forms of business regulation that might apply at the entity level or to a particular kind of activity, but occupational licensure, it applies specifically to individuals practicing a certain profession. It's a credentialing form that's intended to protect public interests by ensuring that licensed individuals are qualified and responsible for performing the regulated activity, and it's subject to appropriate oversight within an administrative agency that administers a particular occupational license. So in Kansas, at the state level, statute provides for licenses and certain kinds of license types that are regulated, and a lot of the requirements associated with licensure are provided for in the regulations of the agency themselves. And in terms of the number of licenses, it's pretty difficult to know exactly how many licenses are being administered at the state level, just because for different agencies, they may categorize licenses in ways that, statute may provide for a class of licenses, but then the body has more specific categories of licensure within that license type. And so the actual number of licenses is kind of in flux. And just depends on how, the profession is organized and what kinds of licenses are required by statute. But KLRD reports on occupational licensure for a bill on expedited licensing that was introduced a few years ago. And so we obtain reporting on statutory requirements for that expedited credentialing program. And so we have a pretty good idea of how many licenses there are, but then there are a few that we don't really get reports on or that are not part of that expedited credentialing law. So for those reasons, it's just difficult to know exactly how many licenses there are, but we receive reports on about 100 different license types from 21 credentialing bodies. So that's at the state level. There are other kinds of professions that are regulated in terms of licensure at the federal or local level. So like federally, there is credentialing for people in the aviation industry. And then, there's other kinds of licensing regulations that apply to commercial truck drivers, for instance, and those are because of the federal regulations that regulate those industries. In the construction industry is kind of one place in Kansas in particular where Other states may license at the state level, but Kansas generally does not. We previously had a licensing board for home inspectors, and those regulations were sunset, or that statute that provided for the licensing of home inspectors sunset in 2013. But on page 2 at the top, just pointing out that Kansas is one of only 6 states that doesn't license plumbers at the state level. And we're one of only 9 states that doesn't require some kind of licensing of electricians at the state level, and one of 13 states that doesn't offer some kind of interstate reciprocity of interstate licensing, or of electrician licensing. So for electricians and plumbers and those kinds of trades, if licensing is required, it's required by at the local level, typically cities. There are a few other trades that are licensed in some states, but not in Kansas. Some states license general contractors or painters, but those are less common than plumbing, electricians, HVAC technicians. And then there are some professions that Kansas doesn't regulate that are much more commonly regulated, like massage therapy. Although, I mean, it kind of varies, but massage therapy and certain cosmetology practices in Kansas may be regulated or licensed at the state level in other states. So I've mentioned interstate licensing compacts. In Kansas, to date, we have enacted 14 interstate licensing compacts. And I'm going to talk a little bit more about what those compacts are after this presentation. But what those compacts are basically agreements that we enact in statute to join a compact, and then this is a compact with other states, and then across states they work out kind of the details of how it's going to be administered and what the sort of standards of credentialing are going to be required for every state that's participating in the compact. This doesn't preempt a state's right to regulate its own licenses, and that's important because it's still a lot of requirements are dictated by the compact, but the regulatory authority for the license still remains with the state. We're not ceding our authority by joining into those compacts, and the licensing bodies that administer them are still responsible for the actual administration of credentialing programs. Although one of the benefits of interstate licensure compacts is registration and maintenance of data for individuals that may be subject to the compact. But there are a lot of different ways that plays out depending on the particular compact and how they're organized and how they agree to share data and information and those sorts of things. And then we have reporting requirements, as I mentioned, related to expedited licensure. Those are the primary reporting requirements that the legislature has in terms of hearing about how licensing is working. And the expedited licensure law was one of a number of reforms that happened between 2012 and the present. Kansas has actually been pretty active in reforming its occupational licensure regulations and laws. In 2012, this started with reciprocal credentialing of active duty military, spouses of active duty military members. Those members, so I didn't mention reciprocity, but basically it's the recognition of a license from out of state, mutual recognition of licenses from another state. And so reciprocity agreements kind of predated the interstate compacts in that individual states would recognize other states that had similar standards of practice for licensure. And so they would agree to recognize anybody who was licensed in that state. But with the expedited licensure program and the credentials for military spouses that began in 2012, that was that was Kansas decided to recognize credentials for military member spouses if they were practicing a similar profession in another state. And that has actually been expanded quite a bit. So similar provisions were added for veterans in 2013, and then active duty service members were added in 2015. And then in 2021, when we enacted the expedited credentialing, it was extended to all spouses of military members, regardless of active duty status. And then it also, it made changes to that 2021 law provided for expedited credentialing, which required that licensing bodies administer credentials within a certain time period. So for military members and military spouses, that was a 30-day timeline for assigning the license, and then 60 days for qualified out-of-state applicants. So we have expedited licensure for applicants in all of those regulated professions in Kansas. It also provided for temporary licensing, and then Kansas has made a couple of efforts to remove or reduce the fees that are associated with licensure. So in 2024 and 2025, military service members and spouses were exempted from any fees related to applications associated with obtaining a license. And then on page 4, there's a list of bullet points, just other things that Kansas has done to reform occupational licensure. There have been a number of cases where we've exempted some occupational practice from regulation. So examples of that include in 2022, there were a few bills that SB 40 authorized occupational therapists to provide limited service without referral from a healthcare provider under certain conditions. In 2022, SB 348, it removed certain threading methods, which is a cosmetology practice, from regulation under cosmetology licensure. SB 453 permitted clinical social workers to have supervised postgraduate experience in lieu of completion of a graduate level supervised clinical practicum. And then with those changes to the regulations, sometimes they're typically enacted with some kind of provision that offsets the impact, like increasing liability requirements. So it may be exempted from direct regulation or requirement that they be licensed by the state, but they may have higher personal liability requirements, or more of a requirement to provide certain information to clients. So those are all some of the ways that Kansas has enacted reforms to its occupational licensure. And then again, participation in interstate licensing compacts. This is one way that once compacts are functioning and working the way that they're intended to work, it greatly streamlines the occupational licensing process, and it allows for greater mobility of practitioners to move across state lines and practice their profession. And so at the bottom of page 4, there's a list of bullet points of just the licensure compacts that were enacted since 2021. And those include audiology and speech language pathology, counseling, cosmetologist, dentists and dental hygienists, dietitians, interstate teacher mobility compact, physician assistants, school psychologists, and social workers. And we're going to hear some testimony from a couple of the agencies that administer compacts, so they'll be able to give you some good specifics about the way that compacts work and the kind of just more technical information about compacts. But And then one additional thing of note that Charles from the Revisor's Office is going to discuss today was a bill, SB 30, that was introduced last year. It was SB 229, and it became, in a conference committee report, SB 30. But it was a reform to occupational licensing that would have required annual reporting of certain information to the Joint Committee on Administrative Rules and Regulations. And it would have required new occupational licenses and material changes to existing licenses to be approved by the legislature before being adopted. And as part of that consideration, KLRD would have been required to conduct a review and submit certain information to the legislature regarding the rationale for the proposed requirement changes, comparison with requirements in other states, and alternative measures for achieving the intended purpose of the proposed requirement. And that bill, the conference committee report, was adopted by the House but was not taken up by the Senate before we adjourned. And with that, I'll pause to address any questions you might have about occupational licensure in general before moving on to talking about the compacts that have been enacted in Kansas.
Committee, any questions? Senator Falscadeau.
Thank you, Mr. Chairman. So regarding the licensure and for spouses of military individuals. So I know we've passed legislation to kind of, if they move to Kansas, to help them, get positions or certified immediately. So, but are they still required to do the test to show that they have those skills?
Yeah, I mean, there may be, and I can't recall exactly, but I believe that the statute requires similar, requirements for the credentialing that they would have had in another state, and it provides for, what is similar scope of practice. But when someone doesn't meet the requirements, part of that law provided for temporary credentialing so that they could, obtain any additional training or meet any additional requirements that Kansas law provides for.
Mr. Chairman, and so, but still, so we're expediting their ability to be certified and gain employment, but I guess I'm just trying to confirm, are we requiring them to do all of the testing as we would any other person?
Yes, I believe
Okay.
I believe the law requires essentially the similar or more or less the same requirements that they have completed those, and if they haven't, then they're allowed to practice provisionally while being given a timeline for fulfilling those additional requirements by the state. Sure.
Any further questions? I've got one. You said something about reciprocity.
Reciprocity.
That, what he said. And would that be a better way to go than a compact? Because it seems like we would just be recognizing the license and they could come here and work, versus a compact. We're going to discover that we're having a lot of problems with a lot of those later. So would it be, is that a simple fix, just to say we're going to recognize licenses from these states that are in the compact?
I mean, that is one approach that states take. It would be under the umbrella of what's called universal licensure. And I'm not familiar enough with how that actually works in other states. In preparing for this meeting, we reached out to all of the agencies that administer occupational licenses, and we asked them if they were participating in a compact, and just to get some feedback about their experience with the compact, how it's being administered, and any any kind of feedback or suggestions that they may have. And I'll go over some of that in a minute. But one of the things that did come up, there were a few responses from agencies that don't administer compacts that said essentially that that's what they're doing, is they already kind of have a system of reciprocal credentialing that works pretty well nationally. The problem with reciprocity is that, and this is kind of part of the issue with compacts as well, is that different states see things very differently. And so, with reciprocity agreements, it's, more on a case-by-case basis, and requires more administrative hurdles, I guess, to enact reciprocity by the agencies. That's my understanding. With the compact, a lot of the planning and comparison of the requirements between states is happening before states are even joining the compact. And so it's basically just signing on to those agreements, whereas reciprocity agreements is more kind of an active ongoing process that requires a little bit more administration, I think.
Yes, Senator Dietrich, yes.
Thank you, Mr. Chair. So thank you for that. So at NCSL, we did a little boot camp on licensure, reciprocity versus compacts. And one of the values of a compact, if you are interested in forming a compact like we have with many of our occupations, is that when you become as a state a member of a compact, you're agreeing that your licensing requirements are similar, if not exactly like the other states in that compact. So it still expedites the licensing process, but it just gives you that, especially in the telehealth and healthcare fields, that you from, let's just say Nebraska, are trained the same way I am from Kansas. So that it just gives you that security piece that we are part of a compact. Everybody agrees this is what you need to be able to do this job, and it's a little different than reciprocity.
Thanks. Thank you. Any further discussion before we move on? All right, seeing none, go ahead. Thanks.
Sure. So I'm going to move on to, this is the second bullet point on your agenda. It's overview of interstate licensure compacts enacted in Kansas. And I'm not going to get into any of the specifics of individual compacts. I just kind of want to go through what we've enacted and kind of where they're at in terms of their operation. So as I mentioned, Kansas to date has enacted 14 interstate compacts of 17 that the state could otherwise be eligible to participate in. So those are, well, before I get into that, I'm going to be, you have a table that says interstate licensure compacts enacted in Kansas. And so I'm going to be kind of walking through this document. And then I also have as written only testimony, just for your reference, there's a second set of tables on a page. It says nurse licensure statistics provided by the Board of Nursing. I'll kind of refer to that in a minute. I think there's some trends that are helpful for seeing what happens when compacts are enacted. And then we also have a memo that has a lot of really good specific information about these compacts in the medical or healthcare licensure that we've enacted in Kansas. That memo is entitled Interstate Healthcare Professional Licensure Compacts. That's just for your reference if you want to get into kind of more what the compacts do and what the history of them is. But so looking at this, the table that you have in front of you, the interstate licensure compacts enacted in Kansas, you can see all of the compacts that we've enacted, and then at the bottom, so across the top of the table, the headings have the name of the compact, has the year that we enacted it, it has the statute reference if we have it assigned or if it's been published. There are a few that have been assigned but have not been published yet, is my understanding. And then the agency that administers the compact, and then the columns on the right, the number of member states, those are the states that have agreed to participate in the compact. The issuing states are the states that to date are issuing credentials or providing for compact privileges. And then the next column, it says minimum state threshold. That was the original threshold that was required, the number of states that were required to join before the compact could become operational. And then the date for each compact that threshold was met. And then if they began issuing licenses already, the date that credentials were first beginning to be issued under the compact. And then in Kansas, if we've enacted a compact, the compact licenses are being issued somewhere under that compact, then the date that Kansas first began issuing those licenses. So the way that compacts work generally is that there's kind of a planning commission or a drafting that happens. So language is drafted. There's kind of a review of all different states that could potentially participate. They review as many states as they can to see how they can make the credentialing fit across as many states as possible. And they start thinking about drafting the language of the compact. Then when states start enacting that legislation, once a minimum number of states reach the threshold that the compact becomes operational, then a commission has to be established where delegates from each of the states that are participating in the compact, they meet and they start to discuss the kind of administration of the compact. So how data is going to be collected and maintained, and what states' responsibilities are going to be in the administration of the compact, and whether there's any cost sharing that's going to be involved in the what is provided by the compact commission, those sorts of things. And then states themselves have to adopt rules and regulations in order to administer the compacts. So this is kind of the nature of the process. And I've been told that for most compacts, from the beginning of drafting until a given state is issuing licenses, it can be 5 to 7 years in that whole process. So that's part of the reason why a lot of these compacts that we have enacted recently, for most of them, if you look at the table, kind of at the bottom of the list of compacts that have an enactment date, the ones that were enacted in 2024 and 2025, Kansas is not issuing licenses for any of those compacts. But if you look in the column that says issuing states, you'll see that none of the states that are a part of that compact are issuing licenses under those compacts. And those are the dental and dental hygienist compact, social work licensure, cosmetology, dietitians, and physician's assistants. Also the school psychologist licensure compact that is not being currently, licenses are not being issued under that as well. And then as you kind of move towards the top of the table, you can see that where, in general, the longer a compact has been enacted, the more of the member states are actually issuing licenses. So the oldest ones were enacted in Kansas in 2016, and those were the Interstate Medical Licensure Compact, and we'll have a conferee after me that can talk more about that. And then the EMS service, or emergency medical services personnel licensure. And we received feedback from basically the agencies that have been administering compacts for some time and they've been working. They all responded saying they're working as they're intended. It has increased participation and allowed for greater mobility, and it's greatly streamlined the process for licensing people to practice those professions. That was the feedback that we received. And then it was kind of mixed in terms of the compacts that have been a little bit more recently enacted. And then there are some challenges like the audiology and speech language pathology compact. It was enacted in 2021 in Kansas, and the minimum number of states that joined that compact happened in 2020, but you can see that to date, no states are issuing licenses under that compact, and they've just run into some roadblocks with that I'm not totally familiar with. But they don't have a target date currently for when they think they're going to begin issuing licenses under that compact. I would also point out, for some of them there is a target date. So a number of the more recent ones, they're planning on beginning to issue licenses in 2026, and some of them in 2027. Maybe I'll just kind of wrap up with some of the feedback that I received from agencies in terms of what could be done differently and kind of how the compacts are working. As I said, if compacts are being implemented, then they are generally working well and leading to increased participation. Chairman Tarwater mentioned the reciprocity or universal licensing. The Department of Education administers the Interstate Teacher Mobility Compact, which works a little bit differently than some of the other licenses, because my understanding from communicating with the Department of Education is that all of the teachers that they are currently licensing are being licensed under that compact. From a number of other compacts, the participation in the compact by the practitioner is optional. So they don't necessarily have to apply to be licensed under the compact, where they would have privileges to practice in across state lines in those member states. So that's one important difference. So the Teacher Mobility Compact kind of has the effect of what the chairman mentioned in terms of universal licensure, but there are not very many states that are participating in that compact to date, and that probably is because of the disagreements about how that licensing should take place. But I can't really say if that's the case. But there's 14 states currently that are participating in that compact, and we also heard from the Board of Healing Arts, who we're going to hear from after me, that about half of their medical licenses are licensed under the Interstate Medical Licensure Compact, and that issuing licenses under the compact is more straightforward or more efficient than it is to administer a Kansas license, because of the as Senator Dietrich was talking about, the acknowledgement that it's kind of the questions about requirements are more settled, I guess. We also heard some agencies indicated they have concerns that states having different standards could potentially lead to lower standards for licensure in Kansas than we would otherwise have in statute. And then a number of agencies noted issues with background check requirements that are in the process of being worked out with the KBI, and that has kind of slowed down implementation of some of these compacts. And we're going to hear from a representative of the KBI today on that as well. And then some improvements. Some people suggested increasing promotion to encourage participation from other states. We had some feedback that it would have been helpful if the state had conducted an economic impact statement prior to the enactment of the compact, that would allow for better planning and resource allocation. And in a related note, a few agencies noted that utilizing interstate compacts, issuing credentials under those compacts results in fewer state licenses being issued, and that has an impact on revenue because it reduces the revenue that they were receiving under state licensure. And so I might direct your attention to this nurse licensure statistics page. Is the next document in your testimony, and this is related to the point that I just brought up. You can see in the the first table on top, it's the number of licenses that are being issued by the type of license. And there are single state and multi-state licenses for their registered nurse credential and their licensed practical nurse credentials. And if you go down, you can see that those started being issued in fiscal year 2020. And you can see from 2020 to 2025, that the number of multi-state licenses has increased quite a bit over time. And then on to the far right, there are two columns split off that show the number of total licenses that are being issued and the percentage that are being issued as multi-state licenses as a percentage of all of their licenses. And so that you can just see the trend in increased participation in the interstate licensing. And then the bottom table is just for reference. It's the number of renewal licenses, and there's kind of a trend as time goes on that the number of renewal licenses is decreasing because of licensure in the compact. So it's the number of state level renewal licenses is my understanding. I think I've given you plenty to think about. So with that, maybe I'll just stand for any questions that you may have.
Okay, we'll open it for questions. Senator Owens?
Thank you, Mr. Chair, and thank you for this, Eric. This is a lot of great information. I was just curious, I see the APRNs. We've had looks like a significant increase in the licensure of APRNs, which is a great thing. Do they not have a multi-state compact?
So that is one of the three compacts that Kansas is eligible to participate in, but is not, that we haven't enacted yet. And so it's a separate compact from, it's the Enhanced Nurse Licensure Compact, and then there's the APRN Compact, so.
Okay, well, thank you. I think it's actually really promising to see that we've almost doubled the number of APRNs in the last 7 years in our state, which is really good, so thank you.
Senator Alley?
Thank you, Mr. Chair. Did I hear you right that said that because of these compacts, the amount of fees that we're collecting in Kansas for the licensure has gone down? Is that correct?
That was the feedback that I received from some agencies, and I'm not sure if that applies to the way that all of the compacts are administered, but I would believe that any licensing where there's an opt-in, there's probably a difference in how the application process happens and, where the credentials coming from.
Let's just say that I wanted to join the compact for an RN, for example. Where is that compact located? And I mean, if Kansas isn't the location for that licensure, where is that and who keeps the money?
I don't actually know about the distribution of any kind of revenue that's generated from the licensing. It may, so I can't speak on that. Maybe one of our next conferees can talk about that. But in terms of where the body is located, they organize and they have a commission that meets in a particular place, and it's just I'm not sure if they have administrative offices for that commission or not, but I know that they have fairly regular meetings where the commission delegates meet. But the next conferees will be able to address that question a little better.
Okay, thank you.
So why not dual licensing if we're going to license a nurse or a physical therapist when that one gets going? Why not license them in Kansas and in the compact, or is it just automatic that they go to the compact?
So that is, I think it sort of depends. Like the teacher mobility compact, that's kind of automatic in terms of licensing under the compact. But for most of them, this was actually a point that was brought up, and I think it was David Fye from Behavioral Sciences Regulatory Board who's going to be on WebEx at 2 presentations from now. But someone mentioned to me, and I believe it was David, if not, he can correct me, but that it would be helpful to have language in statute that provides for opting in or not. Because my understanding is that there's some lack of clarity with that, where either the compact was enacted and there wasn't an option to opt in. Someone also mentioned that with regard to opting in, that the compact only provided for the way that Kansas statute enacted the compact, only provided for new licensees to be licensed under the compact. And so there was, mentioned that it might be helpful as we think about this to provide either or language. And I think that it would be a policy question as to your specific question about dual licensing.
Charles, is that something we could do universally, or would we have to open every one of these statutes? He was talking about either or. Some of these don't have language in it that allows for current licensed individuals to participate in the compact, and some of them, it's just not clear that anyone could participate in the compact or in either or situation, and some don't have opt-in, so therefore we can't offer it because no one can opt in. Is that how I understood what you said, Eric?
Yeah, and I think the other part of your question too was whether or not dual licensure, if it makes sense for a particular license, whether you could require licensure at both the state level, issuing a state license and a license under the compact, whether or not that's something that would be possible, and whether you could do it universally or whether it would have to be specific to each of the compacts.
Revisor Reimer.
So a couple of things. One is that the Constitution provides that the legislature has the authority to modify compacts. So then the issue would be, well, does that, how do the other states in the compact feel about that, I guess, and whether that would take us out of the compact. The other thing is that just looking at some compacts, some of them have provisions, sort of dual licensing provisions where, there's a procedure for just an in-state license, and then there's a procedure for a multi-state license that has to meet certain other provisions. So I guess I would have to look at it further, but I don't know if that heads toward the answering of your question or not. I mean, it's certainly something that the legislature could look at.
Okay, so the answer is it's complicated. Got it. Got it. Representative Turk.
Yeah, I was going to add, it sounds like I doubt we'd be able to open it up universally. We might have to like group them off, like M&Ms, yellows with yellows, blues with blues, that kind of thing. But I doubt we'd be able to universally fix it. It sounds complicated. It sounds like it could be an entire session adventure.
That's certainly not the goal. Eric, on a lot of these, the ones you said that we're issuing zero, even though we have the right amount of states, but no state is issuing any license. Are they all having the same problems we are with the FBI backgrounds, or is it?
I'm not sure how universal that issue is. I think for some of them, it just is because they're still relatively new, and for some of them, I can't remember. There's a compact that just began issuing licenses in September, and so states that were in on that compact early on will be the first ones that are issuing licenses. But for Kansas, if we adopted it a little later, that just means we have to work through some of the administrative issues before we can actually begin issuing licenses. So part of it is just that they're in different phases of development. Maybe the Compact Commission hasn't met yet, or maybe they've met, but the Compact Commission is still working out administrative issues for all of the states, or individual states are in the process of writing their rules and regulations.
Is there a reason that they would purposely slow walk these things? I mean, it seems like the legislature creates these things and then the administration may not like it. and therefore they don't want to lose their people. You know, we're licensing people in Kansas. We don't want to lose them to another state. Maybe that's the reason that people find reasons to make these things not work.
I mean, I can't speak to other people's intentions, but the feedback that I received suggested that the reasons for non-implementation to date are largely out of the agency's control.
Senator Tyson.
Thank you, Mr. Chairman, and we're very lucky to have the Chair of Rules and Regs in here, and we have witnessed what you said specifically. In fact, there is some agencies and departments, 7, 10, 15 years, they have not implemented, even though the statute has a deadline that it will be implemented by a certain date, and they choose to ignore it. It's very egregious. I wish, I don't know how to make that more obvious to our colleagues, but it is a major problem. Thank you, Mr. Chairman.
All right, seeing no more comments on the compacts. Thank you very much. Thanks for putting that together. Very interesting stuff. All right, so next we're going to talk about the physical therapy compact challenges, and we'll start with, so John, did you want to start, or do you want Nicole to go first? Okay. Nicole Maddox. Oh, we missed somebody, but go ahead. We'll go with you, and then we'll, unless they're in a particular order. All right, let's go ahead and start with the agent. I'm sorry to call you up. All right, we'll start with the agency, Susan Guile. Is she online? WebEx? Okay.
Good morning. Can you hear me?
Yes.
Okay. Good morning, Chair Towerwater and honorable committee members. My name is Susan Guile, and I am the Executive Director of the Kansas State Board of Healing Arts. And the board is the executive body tasked with licensing and regulating 16 different health whom are licensed healthcare professionals from various professions. We have 8 licensed physicians, 3 chiropractors, 1 podiatrist, and 3 public members. Statutory mission of the board, as I think you all know, is public protection. I heard the first presentation, and I appreciate a lot of the information that was shared. The board, as he talked about, we do have the Interstate Medical License Compact that is up and running and has been since about 2017. The PT Compact was passed by the legislature, I believe, in 2022. We are not issuing compact privileges under the PT Compact yet, hopefully soon. We've been waiting on the FBI to approve us, to approve our statutory authority to do fingerprint background checks. We received information this week that has been approved, so we're very excited about that. I'm on WebEx today because I'm actually in Spokane at a PT meeting, so that information will be received very happily and will be much celebrated this week, so very excited about that. So we'll be working with the KBI to get all of that implemented and hopefully be issuing privileges very soon. The PA Compact was approved just this legislative session, 2025. And as he mentioned, I'm on the, well, he didn't mention this part, but I am on the PA Commission. And as he mentioned, we'll be working on the rules for that compact. Right now, we're drafting rules related to IT, information sharing, and discipline. And so I think, if memory serves, I think 2027 is when the PA Commission hopes to be issuing PA compact privileges. You all have my testimony, so I won't read it and go through specific questions or specific information you'd like to know. I'd be happy to talk about it. What I will say about the medical compact is that's the only one that is active right now, is it is very efficient. It is a much quicker way to licensure. And what happens typically, I'll just talk a little bit about what I've heard this morning, is it is different than reciprocity. We do have statutory authority to do license by endorsement, which would be someone who has an active license in another state, but also wants an active license in Kansas. That's one pathway. It is also quicker than a traditional application. What the compact does is it allows someone to apply for multiple state licenses in one place. They go to one website and they apply for multiple state licenses in one sort of process. It's quicker, it's easier. Now for us, they do still pay for their Kansas license. We get the same amount of money for an active Kansas license from someone in Colorado that's applying for a Kansas license as if they are here in Kansas. They renew annually with us. They pay for that annual renewal. Some of them are coming to Kansas to practice, some aren't. A lot of them are using it for, there's a lot of radiologists, a lot of radiology readings that are being done remotely. They still have to have a Kansas license to do that. Yeah, I don't know if there are questions that I can answer or what else you want to. Oh, one thing I do want to hit on, one big thing about a compact. One of the things that's really nice is if someone has a license in another state, there's a disciplinary issue. Disciplinary issues to the compact, and then they send that out to every state that that person has a license in via the compact. So we're informed immediately. I'm sorry, is that coming up on your screen? We're informed immediately that that person has had discipline, and then that allows us the ability, the other compact states, the ability to review that discipline and take like disciplinary action if appropriate. So that is a big benefit of the compact. Are there, I would stand for questions if there are any.
Committee, any questions for Susan? Representative Turk.
Thank you, Mr. Chair. Susan, with the new information from the FBI, what's the timeline for the implementation of the PT compact?
So thank you for that question. I understand that Nicole Maddox from the KBI will be here later today. She and I have been emailing back and forth about this, and my understanding from her is that the KBI has some infrastructure type things they need to do to be ready to process those. My staff has some information, or excuse me, some work that we need to do on our back end to finalize. And so she and I have been emailing this week, and I'm sort of shooting for maybe a December 1 timeline. We may be able to do it quicker, but I want to have a firm date that we can start saying, you know, this is the date that we started issuing privileges. So that's kind of what we're thinking, but I don't know. I haven't heard from her to know for sure what their timeline will be on their end.
Okay, so on that note, it looks like there's 35 states that are currently issuing licenses in the compact. Did they not have the similar problems that we're having with the FBI background checks?
Some did. Thank you for that question. Some did. Some were already fingerprinting PTs before they joined the compact. Others had similar issues, maybe not quite as long of a period of time. So it varied.
Okay, so if there's a physical therapist that is in the compact, are we honoring their license or are we not honoring their license right now?
I'm not sure I understand. So you mean if they're in the compact and they want to practice in Kansas, can they get a compact privilege in Kansas? Is that your question?
Right, because they're in the compact because that state, that particular state has approval from the KBI or from the FBI to do background checks, so they're in the compact. Are we honoring those licenses when they come to Missouri or not? I mean, Kansas.
Today, no, because we can't. because we cannot do fingerprint background checks. We cannot issue compact privileges. So we cannot be live in the compact yet.
Okay. Any further questions? Thanks for the information and good luck on your meeting today.
All right. Thank you so much.
All right. Okay. David Fry, Behavioral Science Regulatory Board. Is he online too, WebEx? Okay.
Morning, Mr. Chairman, members of the committee. Can you hear me okay?
Yes. Thanks
Great.
for being here.
Thank you. Well, thank you for your flexibility. I am the Executive Director for the Behavioral Sciences Regulatory Board. I am currently out of state attending a meeting with the Association for State and Provincial Psychology Boards, and I was one of about 7 appointed members of a task force, and so I'm here trying to represent the state, but I'm happy to present testimony, so thank you for letting me remotely. And just to let you know too, when the testimony concludes, I'm happy to answer any questions. And if it's, I don't want to be disrespectful to you or your committee. I just am playing double duty, so I may have to run back down to the meeting right afterwards, if that's okay with you all. So, in my testimony before you, I did go ahead and describe, the professions regulated by the BSRB. There are 7 mental health or behavioral health professions. Those include psychology, social work, professional counseling, marriage and family therapy, master's level psychology, addiction counseling, and also behavior analysis. Kansas has joined 3 multi-state compacts for the professions regulated by the BSRB. The 3 compacts that are connected to the BSRB are SIPAC, which is also known as the Psychological Interjurisdictional Compact. There is the Social Work Multi-State Compact, and then there is a compact for professional counseling. It's important to understand that each of these was designed very differently, and they operate very differently. So I'll just provide a little bit of information about where we're at with those compacts and then how they function, and then perhaps what we're looking for the future to help things work even more smoothly. Just a note too, there was mentioned a 4th compact that is also for school psychologists. And just for clarity, school psychologists are regulated by the Department of Education in Kansas. So that one doesn't really connect to the agency, but I thought I'd address that up front for clarity. In my comments and my testimony, I also sort of provide a little background information talking about traditional practice, and that, traditionally the way that people practiced in multiple states was to get licensed in every state, to pay the license fee in every state, and then meet the other requirements, whether that was continuing education, passage of a different test like a jurisprudence examination, which deals with state-specific laws. But as things have changed and mobility has increased for not just practitioners, but also for clients, there was a need for a different solution, especially for professions that involve a lot of telehealth or remote practice. And so it evolved from everyone being licensed in multiple states to the multi-state compacts. And in my testimony, I talk about how some of these originated in different ways. One of the main ways that some of these originated was the Department of Defense made available some grant money, and some of the associations for the professions did seek out some of the grants to spearhead the creation of those compacts. And so that provided some funding for creation of draft model language. One of the entities that helped a lot of this process is the Council for State Governments, or CSG. So you may see them referenced quite a bit for different compacts. But I also, in my testimony, I wanted you to kind of, provide some information on the steps by which you have a compact begin and then to the point to where it's launched, because there's a lot of different steps. And I think Mr. Adele did an excellent job explaining, the different compacts and how they're set up. But I listed several bullets there, so you can kind of see how, there is work that's done on the draft language for the model language. And then there's stakeholders that are assembled to decide, what's going to go in that. And then once the language is all put together, there's minimum number of states that have to pass it. And then you have a compact commission that gets formed. They have to set up the functional rules for the compact commission. You go through different steps, including how to fund the compact going forward, a data system to get all the information that you need, have the data system built. There's usually an RFP process to select a vendor, and then you go through those steps. You test the data before it actually goes live. So as Mr. Adele said, in some of the situations from the origination to the compact going live, there can be maybe 5 to 7 years. And so Going to the first compact that the BSRB is connected to, that is SIPAC. And in my testimony, I talk about how that originated back in 2014 and 15 with some task force and advisory work groups by some of the associations. Ultimately, there was some model language that was determined. It was passed by Arizona back in 2016. Since that point, other states passed it. And in 2019, Georgia was the 7th state to pass it, which was the minimum number of states for a compact commission to begin meeting. So they were doing a lot of the work on that. And Kansas passed that compact in 2021 to be effective starting January 1st, 2022. And we were able to have our licensed psychologists participating under SIPAC as of January 1st, 2022. The way that compact is set up, it is primarily set up for individuals to be able to apply to the SIPAC Commission for the ability to practice telehealth in other compact states. So it is designed primarily not for in-state practice, but to do telehealth. And the vast majority of individuals who have taken advantage of that have done that. That is called the Authorization to Practice Interjurisdictional Telepsychology, or APITS. Far less popular. There was also a way to apply to the SIPAC Commission to practice with a temporary authorization to practice, a TAP, and that allows 30 days of in-state practice in other compact states. But it was primarily designed for teletherapy. You had to have a license in your home state, and then you had to meet any kind of other special requirements in states that you wanted to practice into, such as their jurisprudence examinations. But primarily, you for that privilege, and then you can practice into multiple states by telehealth. Some of the impressions that we've seen from SIPAC so far. So as of September 2025, there's about 1,089 licensed psychologists in Kansas, or licensed by Kansas. Currently, of those, 123 of the licensed psychologists hold either an APIT, and then 11 hold a TAP under SIPAC. So that means we have about an 11% uptake in terms of our licensed psychologists in Kansas. On the SIPAC verification portal, there's also some information there about people who previously held an authorization. So there's about 31 individuals who have previously had that authorization, and it's now expired. I think when you look at other states, the uptake is pretty consistent with that. I think it's usually between 10 and 15%, depending on the state. In terms of the timeline, we joined that compact basically after it was ready to go. And so it was fully functional, and that's why we were able to jump in and have our licensed psychologist immediately start providing or seeking authorizations from the SIPAC Commission. But I do think that may have influenced some of the expectations for some of the timelines for compacts. So SIPAC was a little unique in that we joined that after it was already all put together. For some of the newer ones, we were one of the founding members, and so that timeline is affected accordingly. In terms of the impact on the operations for the BSRB, SIPAC is designed to replace individuals being licensed in multiple states. You can still get licensed in different states, but it was intended to allow for that telehealth option without someone being licensed in, let's say, 5 to 10 states. So there was going to be a decrease in individuals who lived outside of Kansas who were getting a license in Kansas. And we have seen that over the years that we've been active in SIPAC. Normally we have 2-year licenses, but for psychologists, they come up upon their cycle every June of even numbered years. Based on the limited information in the SIPAC verification portal, the first year in 22, we couldn't determine how many people we had lost. But in 2024, there was probably about 25 out-of-state licensees that discontinued their license in Kansas, but we know that they didn't retire because they continue to provide services under SIPAC authority with a different out-of-state license as their home state license. So we know that there was a loss of revenue in addition to the loss of revenue from out-of-state licensees. SIPAC also looks back and charges an assessment to the state, which is paid for by the BSRB. They charge $10 per year for anyone practicing into the compact who lists Kansas as their home state. So every year at the end of the year, they look back and then they send us an assessment or a bill, and then we pay that amount. And so when the legislation was put through as a way to help compensate for the loss of revenue, the legislature was able to put in a $25 fee. And so for individuals practicing under the compact authority, we have the ability to collect that to make up for the lost revenue, or specifically, it's almost a wash with the amount that we're paying back for them for that assessment. Even though we are losing some out-of-state licensees, I think it is notable that there have been an increase in individuals providing telehealth services into the state. Originally, SIPAC was not tracking that, but when we became a member, my board appointed me to be the first commissioner for Kansas, and so I pushed the commission to start collecting more information. One of the concerns we had was if we join this compact, we won't have any idea who's providing services into the state from other states. And so that information was not being collected, but we were able to persuade them to start asking that on their renewals. And so now we have that information for the last few quarters. It appears that over the course of a year, about 150 people or so are providing telehealth services into the state. Now, we don't know how many of those are providing 40 hours, if they're servicing, one client through telehealth, but we do know that there's about 150 people reporting to SIPAC they're providing services into Kansas. So a loss of out-of-state licensees, but in terms of helping members of the public with services, a lot of psychologists providing services into the state. One of the issues with that compact is the way that it was drafted, honestly. That was drafted primarily to promote telehealth, but we've had a number of individuals that have expressed disappointment or frustration that if they leave their home state, they're no longer able to provide telehealth services under SIPAC. The wording of that commission was you have to be within your home state at the time that you are providing those services. So if a practitioner goes on vacation or has to leave, they are not able to use their SIPAC privileges unless they are able to transfer their home state to a different home state. In order to do that, you would still need to be licensed in multiple states that are compact member states. So that kind of goes against what the compact was set up for. But that means that a lot of people have decided to be able to switch their home states when they're traveling. They're not dropping some of the licenses. So that is one of the issues that we have heard. There's also about 600 individuals. Legislature is one about 17 states that licenses master's level psychologists. And unfortunately, when this language was drafted, it did not allow for master's level psychologists to be included. So that is unfortunate. But part of the reason is because, Kansas was not asked to come to the table to be part of the drafting process. And so in my comments before you, I do say that it's critical that we continue to have a voice at a national level to make sure that our licensees aren't excluded from future compacts. In terms of the background check requirement, Kansas, the BSRB for our licensees, we historically have not required a background check, but under the compact, there is a requirement. But the rules committee for this compact said states will be able to come under compliance with that within 10 years of passing the legislation. So we have been moving that direction to make background checks a requirement, but we have that 10-year cushion by the rules committee. So our licensees were able to start practicing immediately, so no one was excluded. So basically for the SIPAC commission, I think that's working really well. Since we have done a lot of the beginning work on that commission, we have transferred the commissioner spot to board member Richard Nobles. He's a psychologist and he is now the commissioner. But I just wanted to give you some feedback on that first compact. The second compact is the social work compact, and this was passed by the Kansas legislature during the 2020 was the minimum differently than SIPAC. So what social work is designed for is it would allow states to issue a multi-state license to bachelor's level social workers, master's level social workers, and also clinical or independent level social workers. So what you would need to do is you would need to have a home state license. And then in addition, if you wanted to practice in multiple states, you could get a multi-state license in your home state, which would allow you to practice in all other compact states, almost like a driver's license. And so that is not just limited to telehealth. You can basically travel back and forth and practice in those different ones. So in terms of the uptake for the social work compact, currently, I give you the numbers in my testimony there of how many licensees we have that are licensed by Kansas. Uptake cannot be determined right now because the compact has not gone live for any states. We're still about a year away from that based on the checkpoints we're reaching. However, we did survey our social workers about a year ago, and there was a lot of support for that compact. So we do believe that once we go live, there will be a lot of individuals signing up for that. We are going very smoothly through the process. The implementation of the social work compact is actually going faster than a lot of the previous compacts, but I do think that there may be some concern based on how quickly we were able to jump into SIPAC because it was already launched. The social work compact, we weren't on the ground floor of drafting the compact, but we were on the ground floor of passing that compact. And so we played a very active role in terms of that compact commission. I was appointed as the compact commissioner for Kansas for the social work compact. And I have served as a member of both the Rules Committee and the Finance Committee and have worked to move that compact forward. We recently made a recommendation to the Executive Council for that commission in terms of a vendor for the data system. And that is the largest big checkpoint. Once a vendor signs an agreement and we have a contract worked out, they will need to build the data system and then have that tested. And then you can go live a little bit after that point. But based on the checkpoints of the other compacts, we're still probably about a year away from social work going live, but really excited with how this compact is moving smoothly and where we're at in that process. However, I will note that one of the issues with the social work compact was we were not reached out to be part of the drafting for that group. And so it is important that we do have a voice at a national level. And so part of the reason why we are volunteering on committees and trying to help with the commission is that as more compacts come up in the future, we really want the voice of Kansas to be heard and the unique aspects of our licensure to be considered when we're drafting these compacts. And then the last compact I'll talk about here is the Professional Counseling Multi-State Compact. And Kansas passed this during the 2023 legislative session. We have been working with the Compact Commission. Laura Shaughnessy, who's the board member for professional counseling, serves as the Compact Commissioner. This compact is also set up very differently than both SIPAC and the Social Work Compact. National Counseling Compact, essentially once it goes live in Kansas, it would allow our individuals that have a home state license as a licensed clinical professional counselor to apply for a privilege to practice in one specific state. And if they want to practice in one state, they will pay that privilege fee. If they practice in a different state, they will pay that privilege fee, but it'll be a different privilege fee based on where you want to practice. Now, if you do get a privilege in a state, you can do telehealth, but you can also do in-person services, but it's based on a privilege model. Unfortunately, this does not include all the professional counselors in Kansas. As it was drafted, it only includes the independent clinical professional counselors. So it doesn't include our LPCs, our licensed professional counselors. And I think one of the issues there was we were not part of the drafting team for that. So our unique licensure was not considered when they were building this compact in that language. But in my testimony, I give you some information there about how many people are licensed currently. In terms of the way that compact has been implemented by that commission, I do have some comments that I would say are somewhat critical of the compact commission for the professional counseling compact, and that the way that they've decided to implement this has broke from precedent of the other compacts. For one thing, with the background check requirement, I mentioned SIPAC said it takes 10 years to come under compliance with that. For the Professional Counseling Compact Commission, what they said is no one will be able to practice under that compact unless they have a background check from their licensure board. So that created a barrier for all of our licensees until we're able to put that background check in place. They also determined that there should be a 60-hour degree determination made by the states that are licensing these individuals. And whereas the other compacts, you make these determinations at the time that someone applies for a privilege or a multi-state license. What the Compact Commission for Professional Counseling has done is they have said, states, we want you to go ahead and do the legwork for us and make these determinations concerning eligibility, and then give us a list of everyone who might meet the qualifications on the off chance that they apply for this compact. And that creates a big burden for states to do that, to reach all this determined eligibility in advance. And instead of doing it the traditional way, which would say if someone wants to actually practice under this, at that point you do the analysis for this. And so we have been working with members of KBI, and I believe we have resolved most of the issues concerning the background check requirement. But one of the issues that was discussed earlier was the opt-in. A little bit of information about that. Our statute, which allowed the board the ability to require background checks, talks about individuals when they make original application for licensure, or individuals who are reinstating a license, or individuals who are under investigation. Well, unfortunately, that doesn't include, or at least it doesn't name specifically individuals who are already licensed that would like to opt in to a compact to get a privilege because they're not applying for a license per se. And also the way this has been administered, the Compact Commission wants us to determine eligibility in advance of someone actually submitting an application for the privilege. And so this made it very difficult, but I think working with our legal counsel and honestly with the individuals from KBI, it's been very helpful to kind of tie back to some of the definitions in other statutes. And so I think that issue has been mostly resolved. I think we're still kind of working on taking the next steps toward implementation, but those have been some of the biggest issues. Concerning the impact on out-of-state licenses, we do think that we will lose individuals who are currently licensed in Kansas to live out of state, but we are hopeful that we will make up for this revenue for the privileges that people will pay when they choose to get a privilege to practice in Kansas. And then just a little note there that, as I mentioned with the other two compacts, we were not asked to be part of the drafting team for the professional counseling compact. And unfortunately, part of that means that some of our level of licenses are not included in the compact, but also that's why we are volunteering for committees and trying to have an active presence now to make sure that for future compacts and future big decisions, we're heard at a national level. And then just one last comment in my testimony before I open it up for questions here. There is a requirement in a lot of the compacts that says if your state has a state-specific test required for licensure, like a jurisprudence exam, then the compacts will require someone to pass that jurisprudence examination too. Kansas, at least the BSRB, does not require a jurisprudence test, although the board does value individuals knowing the state-specific requirements. So I'm happy to announce that to meet this goal, but also not to impose another requirement on our licensees or individuals under the compacts, we are taking an innovative approach. This December, we are launching something that we're calling Jurisprudence Live. And essentially, this will be a 1-hour free webinar, each of our 7 professions, and individuals can choose to attend these webinars, and we will go over the same information that they would see in a jurisprudence examination. But rather than make this a requirement, we are offering this as a free webinar, and if someone attends it, they will get a free hour of continuing education credit. So we're hopeful that will be helpful in meeting the same goal without adding additional requirements. So I realize I included a lot of information. I hope that was helpful to kind of frame this topic and explain the differences between the different compacts and also the timeframes, but I'm happy to answer any additional questions.
Committee, any questions? Senator Foscato.
Thank you, Mr. Chairman. So if, after that background check, if a blemish is found on their record, are they allowed an opportunity or time period to reapply again? How do you handle that?
Yeah, that's a great question. And that is determined separately by different compacts. So what the psychology compact, PsyPAC, it has the most strict language when it comes to disciplinary infractions. And so with limited exception, if you have past discipline, you will likely be ineligible for that compact. And that's not a Kansas choice. That's just how the model language was worded, but there is an ability to make an appeal to the PsyPAC. There's basically a special appeals committee that if you're denied for the ability to practice under PsyPAC, you can appeal that decision to one of their committees, and then they make that decision. For the other compacts, there's different language, and I believe that there is a weighing of the severity of the disciplinary infraction. And I think there's also some language that talks about, are you currently under discipline from your licensing board? So it's a big difference whether you had a past infraction or whether you are currently under discipline. Let's say you're under supervision, or in the past, maybe you had a fine, but it's been several years. So I think for some of those compacts, if it was something in the past, you probably would be able to get a compact privilege. If you are still under discipline, you may have to wait until that expires.
Thank you.
Any further questions? Okay, so David, on the background or on the compact that you mentioned that does not include current licensees, is that a state statute that we did, or is that a compact issue that you're going to try to correct on your end?
This is not the model language. This has to do with a statute authorizing the board to require background checks. So I think it can be something that's resolved looking at that language. And I've been talking with our legal counsel and also with KBI, and we may go ahead and put forth a regulation just to clarify that opt-in based on the way the statutes tie together. But there's a statute that references the definition of licensees, and that licensees does include individuals who are applicants or current licensees. And so you kind of have to read 3 statutes in combination. This is something we were able to work out just recently with talking with KBI, and I understand Nicole Maddox is going to testify. She and I have been talking about this issue too, so she might be able to comment on this as well. But I don't think this has to do with the model language for the compact. I think this would be a state-specific statute that we could possibly modified to be more clear, or connect that to make sure it does definitely include individuals who are currently licensed so they can opt into that.
Okay, thanks. Any Senator Tyson.
Thank you, Mr. Chairman. David, I was a little confused. Thank you for your presentation and all your work. So you said you could fix it through regulation, and then you mentioned statute. So which is it both? Is it?
So as I understand it, in just the recent conversations, I think the issue is resolved, but I do think it would be confusing for individual members in terms of their ability to opt in. So in talking with our legal counsel, I think it may be helpful to put forth a regulation just to kind of clarify the steps people would go for the background check as part of the process, because this will need to be a requirement for the multi-state compacts, but the board is also moving forward on making these background checks a requirement for licensure for all professions when people are getting their licenses new. So I think it can be resolved with under our existing language, but I do think a regulation would be helpful in terms of people understanding that process in a better way.
Will you be filing that as an emergency regulation? Because it seems like this issue, it's bottlenecked and timely. So thank you, Mr. Chairman.
Yeah, and I just wanted to clarify one thing I neglected to mention in my testimony. For professional counseling, there's only been 2 states that have been able to go live. And part of that is the same issues that we're wrestling with in Kansas. So 2 states are live, but all the rest of them are still struggling with meeting the requirements of that compact.
David, so will you be filing it as an emergency regulation or go through the regular rules and regs process?
I'd be happy to do it as emergency so we can make sure that goes into place.
All right, thanks a lot for your time today, and good luck in your meetings.
All right, thank you, Mr.
No
Chairman.
further questions. Okay. Now, Nicole Maddox. Thank you. Yeah.
Good morning, Mr. Chair, Committee. My name is Nicole Maddox. I am the Information Services Division Director at the Kansas Bureau of Investigation. You all have written testimony, but I did want to just kind of highlight some of the things that have been discussed today and tell you a little bit about access to federal criminal history record information, FBI CRI. Each state has the authority to determine whether to conduct particular types of non-criminal justice record checks which provide access to FBI CRI. Criminal history sharing initiatives involving participation in national interstate compacts, associations, or databases, such as those for child placement or employment and licensing in the healthcare industry, are considered to be unauthorized dissemination. For authorized dissemination to occur, there must be an approved statutory authority which allows access to FBI CRI. So ideally, the agency that needs the federal authority would work collaboratively with the KBI to ensure that the language will meet FBI standards. We would together draft that language. Ideally, it would pass legislation, and then the KBI would request the FBI to review the legislation for approval of the language as required in Public Law 92-544. Once the statute is approved, the KBI adheres to a standard turnaround time of 7 to 10 business days to process and disseminate results. However, our current process time is an average of 9 hours and 47 minutes. Unfortunately, the FBI review process has been taking 18 to 24 months. They are telling us that it is now weeks instead of months. I have not seen that, as we have not requested anything to pass since then. A couple of years ago, we began an effort to consolidate 90-plus state statutes into one pointer statute to make it easier for our partners if the FBI requires a terminology change. It could be done in one place versus opening up 60-plus statutes, and it would avoid revocation of approval. That statute was approved. It was submitted to the FBI, Senate Bill 491, was submitted to the FBI in April of 2024. We received final word in October of 2025 on their review. 47 state statutes were approved. 1 state statute was a partial approval. 8 state statutes had outdated language that are under a grace period to fix and re-review until September 30th of 2027. And 5 new statutes were denied. All of our partners have been made aware of these decisions as of this week, along with an explanation of why. And we are working collaboratively on any changes needed to bring forth the legislature to pass. I'm happy to stand for any questions that you may have.
That just sounds like an awful lot to get done. Thanks for getting it all done. And it took them a year and a half to get back to you, and maybe that's why they're outdated. But so is that how it's going to work going forward? I mean, is it anytime we need a background check, we've got to wait several weeks or months?
Moving forward, thank you for the question. Moving forward, anytime we need to make a change to an existing statute or create a new statute, yes, we have to go through the FBI for an approval process. Statutes that are currently in place will continue to operate. So, for example, David Fry was talking about one of his statutes that they may want to change. So he has authority. His authority will not change until or unless the FBI reviews it and makes a different determination. But the work that we went through to streamline all of those statutes into one place should make the FBI approval easier because we have all the required language into one statute.
So when we do a background check on an individual, that'll be quick.
Yeah, our current process time, once we receive approval, is 9 hours and 47 minutes by the time we get the fingerprint card and disseminate out results.
Okay. Well, that's pretty incredible. That's a vast difference. So.
Very precise. As an average, some is much faster.
So, okay. Any questions? Well, it sounds like we're going down. We're getting better anyway.
I feel like we are.
And it looks like there's a couple of meetings going on today about it. So that's interesting that how it's all kind of coming together at the same time we're trying to figure this out. So good. Thank you very much.
You're welcome. Thank you.
Next up will be John Monroe. Welcome to committee.
Thank you, Chairman Tarwaters, members of the committee. My name is John Monroe, and I'm here on behalf of APTA Kansas. You guys have my testimony, so I'm going to go off of it. And actually, what Susan Giles said with the Board of Healing Arts and then the KBI as well, we received the great news that we're actually going to finally get approval December 1st, hopefully December 1st, but that approval from the FBI that we've been waiting on for 4 years since you guys have passed this in 2021. So you passed the PT Compact back in 2021, and since then we've been talking with the Board of Healing Arts. We've been talking with the KBI. We've been talking with our congressional delegation, trying to get the FBI to respond more quickly to this issue. Like, you guys did all the work. We passed the compact a couple years to get it done before 2021, and ever since then, we've been trying to figure out a way to just get that background check. We hadn't required background checks for PTs in Kansas, which is why we had a struggle with getting it done for approval for the PT Compact federally. So once we have that FBI approval, which it sounds like we do now, as of this week, hopefully we can get that passed. I know that's something that every year since 2021, we bring our PT students up here to the State House. The number one issue they always ask about is that compact. And we have, as you mentioned, Chairman, we have all our surrounding states are a member of that compact. 35 states belong to the compact. And so it's a big issue for the PTs here in Kansas. And so I appreciate you guys bringing this to attention. And this is actually very timely because now we actually are getting something done. So I don't want to say it's because the committee was called to talk about the issue, but you guys called and it's happening. So thank you.
I'm sure one didn't have anything to do with the other
No,
because
no.
these meetings have been planned, but the 25 states that are currently issuing licenses, do they do, well, there's 25 that are actually issuing them underneath the compact, I think. We're not one of them, and is that only because of the background checks? Are these other states doing background checks on all of the licensees, and that's why they're being able to participate and we're not?
So when I checked it this morning, under our federal PT compact, 5 states are not a member of, or they have enacted legislation, and then there's 10 states that have not enacted legislation. Those 5 states that have enacted legislation that are not finally approved, I'm not sure the reason why for the other states, but for us, it was the background checks.
Okay. Any questions for Mr. Monroe? Representative Wassinger.
Thank you, Mr. Chair. We can only do background checks through the KBI. That's it. Aren't there other companies that can do background checks that we can alleviate some of that problem? Not that I want to take anything from the KBI, but it seems to me that there are other companies that can do it. Is that the case or not? Am I just making something up?
As far as belonging to the PT compact, for our PTs to be a member of that, the requirement was to go through this process. I can't speak to whether third parties would be allowed or not allowed.
Okay.
This was just a requirement that we had.
So has the KBI said we need to hire 5 more people in order to keep up with all these background checks? Have they told you that they're behind because of that? No.
So it's,
That might
You had
be a
a head
question
nod from the back.
that might be a
that might
question
be
for
something.
Nicole.
Okay, all right.
And I know they've done an excellent job. It's more of the approval from the FBI that's been the issue. It's not the KBI. The KBI has been fantastic. It's been approval of the procedures that's required for the background checks that has been the delay in the process. So it's always been a
FBI,
federal
that's
agency.
the problem. Okay.
Yeah.
Thank you, Mr. Chair.
I think we got to the crux. Okay, so Representative Turk.
Thank you, Mr. Chair. Going back just for our self-improvement, if we could do this all over again and write this legislation, what should we have included, what language should we have included that would have made this process easier and more efficient?
I mean, honestly, like when you guys passed the legislation in 2021, after probably 3-4 years of reviewing it, so we went through multiple iterations throughout the legislature, throughout the legislative process, to get it to the spot where we thought it was good to go. It was only after that the legislation had passed, had been enrolled, put in a statute, that we realized that we had this problem with approval from the FBI. And so I don't know what would have happened to maybe start conversations with them sooner. But as far as work that was done here in the state, we did everything we could on our end. So I think it's just conversations and working with them. So I don't know if there's anything we could have done statewide that would have been different.
So in your opinion, do you think there's any cleanup work on this that needs done?
So when I was talking with Susan over at the Board of Healing Arts, she had mentioned that with us enacting with the FBI approval of this and with the KBI's bill that they passed last year, 491, that creates a template for hopefully the other compacts to move the process forward. So hopefully it's a lot quicker now. Now that we've kind of trailblazed that path, we're hoping that that template that we use for the PT compact can be used similarly for other compacts going forward. So hopefully the other ones don't take 4 or 5 years that we've been waiting on.
So no, we don't need to do anything.
Not at this time. I believe it should be. I mean, we'll keep conversations going. I know there's a lot of other compacts that went into place this last year. I think we have a good system in place. It took a while to get there, but I think where we're at right now is a good spot, and it should move quicker now that we have something in place for the PT compact.
Thank you.
Yeah, and it sounds like from what Nicole said, the work that the KBI has done to put all the statutes in one place and make them kind of uniform is going to be the answer. And then they have a few more changes that I guess they're going to bring this year from what the FBI weighed in on. And so once we get to that point, I think any future compacts should be easier. Senator Titus.
Thank you, Mr. Chair. And just some comment to add some perspective. I've been in an agency that's on the wrong side of one of these background check deals when we had the industrial hemp program at Ag. And basically what you have to do is every time you have a background check, we kind of forget the specifics, but you just have to go to the KBI, make sure they're involved from day one, because the FBI says if you don't have this exact language in statute, we refuse to perform the check. They won't take that exact language in a budget proviso. If they say, nope, that's not good enough authority, it just has to be this exact language. So I think we as legislators just have to be aware anytime we're dealing with a background check, it's a good time to have somebody call the KBI. Is this appropriate? Do we need to change it? And we just have to be mindful of that, because if it's not exactly the way they want it, they just say no, and you have to wait a year. So.
Okay, important safety tip. Thank you. Any further questions or comments? All right, seeing none. Thanks, John. Thanks for bringing this to our attention.
Thanks, Ed.
Okay, next up, William Wilk, Kansas Chamber. Welcome to committee and congratulations.
Thank you. Good morning, Mr. Chairman, members of the committee. My name is William Wilk, Senior Director of Government Affairs for the Kansas Chamber of Commerce. The Kansas Chamber represents small, medium, and large-sized businesses across the state advocating for policies to improve the economic climate in Kansas. We appreciate the opportunity to provide testimony on occupational licensing today. An occupational license is essentially a permit issued by the state government allowing an individual to work in a particular field. You all have the unique job of setting occupational licensing requirements for licensee holders in the state of Kansas. According to the Institute for Justice, 1 in 5 Kansans must obtain an occupational license to legally do their job in Kansas. The Kansas Chamber has supported and will continue to support efforts to reduce regulatory barriers, and one such policy is promoting licensing reciprocity across state lines. If an individual wants to come to Kansas to work and they need an occupational license, the process should be quick, smooth, and efficient, especially if they have worked as a licensed professional in another state. The Kansas Chamber has advocated for the passage of occupational licensing compacts, which are Department of Defense initiatives designed to streamline the licensing process for military spouses moving across state lines. These compacts, as you've heard, they do not add any additional licensing requirements, change the Kansas licensing standards for occupations, nor change the continuing education requirements. Kansas has been regarded as a leader in passing occupational licensing compacts, as the legislature has passed 14 of the 20 available occupational licensing compacts. In my testimony, I did flag the background check issue, and I had submitted my testimony before I was made aware of the FBI finally approving of the language. Leading up to this hearing, I did have a call with CSG, who drafts all the compacts, and they had flagged some language for me that I put in my testimony that Pennsylvania and Maine had passed to kind of help solve the background check issue. It just establishes statutory framework when it comes to criminal background check and data sharing for occupational licensee holders. But given that we have gotten approval for the FBI, everything should be good now. But yeah, in closing, we just appreciate the legislature's efforts to look at ways to reduce government-imposed barriers on occupational licensing requirements. And with that, I'm happy to stand for questions.
Thank you, sir. The Chamber championed the 4 that passed last year, and you mentioned that there are still 5 out there. Are you guys going to take those up this year? Or?
Yes, this year we will be introducing occupational therapists, athletic trainers, estheticians, and respiratory therapist compacts.
Okay. That's good news, I guess. So, Senator Tyson.
Thank you, Mr. Chairman. Why all the push on the compacts? I'm probably one of the minority on this committee that is not a big fan of them because depending on how much say we have on the board of the compact, we have other states driving our policy, driving our standards for professionals. So why all the push on the compacts and not the reciprocity? Reciprocity would make it much simpler, much more cost-effective, and we would still have the say over the guidelines.
For the compacts, you still have the say for the guidelines, so an individual still has to comply with Kansas licensing requirements when they're practicing in Kansas under the compact. I think it was mentioned in a question earlier when it comes to the difference of reciprocity and compacts. The compacts, I mean, they're for one specific occupation, so it just helps streamline the process.
Senator Tyson.
Thank you, but you didn't address the concern. Let me give you an example of, not with the compact, but with another, we were going to adopt some fire standards that were standards that were put in by the federal government. And it would have required all new houses being built in the state of Kansas to put sprinkler systems in, if we would have adopted those. So the same thing happens to us if we're not cautious on these compacts. I mean, the streamline compact, it's not licenses, but it's the same thing. They control legislation that's acceptable for the state of Kansas. Yes, there is a benefit, but the cost reward. I just don't hear the cost usually outweighs the benefit. And thank you, Mr. Chairman.
I'm happy to do some, I mean, I'm not familiar with the sprinkler system one, but I'm happy to do some research just to give you some cost benefit analysis too. Mm-hmm.
Representative Turk.
Never mind. I'm good.
Any further questions? Could we do both? Reciprocity and compacts?
I believe you could, yes.
Okay. All right. Seeing no further questions, thank you very much.
Thank you.
Okay, kind of jumping ahead of schedule here. I'm going to call on Representative Wilcott to introduce his next conferee.
Thank you, Mr. Chairman. Next up is going to be Jim Smelsley, who is a representative of Northwind Technical Services, which is an employer outside of Sabetha, Kansas, a little tiny town that provides services both nationally and internationally. They're he'll give you a much better rundown of it, but basically an engineering manufacturing company that designs, fabricates, installs, and then starts up and integrates control panels. A large company. Every time you go to the grocery store, the store, most likely something in your shopping cart came from one of their customers that they've integrated some of their systems in. So that's a quick introduction here. He'll be talking about a topic that they've run into some hurdles with and some ideas around what may make it a little easier for them to take some of their Kansas employees and give them opportunities around the rest of the country.
To committee, Mr. Smelsley.
Sorry. I'm the Director of Manufacturing at Northwind Technical Services. Our main office is currently in Sabetha, Kansas. We have about 60 employees. We have an office in Kansas City that houses about another 15 employees, and an office in Costa Rica with an additional 20. So Northwind has built a strong reputation serving clients throughout Kansas and across the continental United States as well as internationally. As a Kansas-based company, we're proud to contribute to our state's economy while serving clients nationwide. However, we've encountered significant regulatory barriers that limits our ability to fully leverage our Kansas-based workforce and expertise in the national marketplace. This challenge isn't unique to Northwind. It affects electrical contractors throughout Kansas and represents a broader competitive disadvantage to our state's electrical industry. So with that said, I think you all have the testimony and document that we provided. I am not going to go through that line by line, but I wanted to touch on some of the topics. The big one being Kansas has no statewide license reciprocity, thank you, agreements with other states because licenses aren't issued at the state level. This in turn makes it difficult for us to send Kansas licensed electricians to work on projects in other states without additional licensing, which in turn leads to a ton of additional cost, the administrative burden of trying to track the licenses for all of our employees. We cannot quickly deploy experienced Kansas electrician to urgent projects in other states. And competitive disadvantage, companies based in states with agreements in place can easily expand their workforce across state lines. And then there were some other issues. Kansas electricians may seek employment with companies that can offer more geographic mobility. And for companies like us, the reduced ability to take on large-scale, multi-state industrial projects. So with that said, a recommendation would be the legislature should consider establishing a statewide electrical licensing system with agreements to enhance Kansas-based electrical contractors' competitiveness in the national marketplace and support the growth of companies like Northwind. Okay. And I know there's a lot of other states that are doing this already. Nebraska being one of them. I think they have 8 or 9. North Carolina, I believe, is 11. Texas has 10. So there's other places we can look to see how it's being done. But that's all I have, so stand for any questions.
Okay, thanks. So right now, the state of Kansas does not license electricians. We're relying on locals to do that. And there's like a patchwork, and everywhere you send somebody, they have to be licensed in a different way. Is that true?
Correct.
And that license doesn't work in any other state because it's not a state license?
Correct.
Okay, and then, so when you have to service an account or install something in Nebraska, do you have to hire somebody from Nebraska to do that? Was that easier?
Either hire somebody from Nebraska or have someone go get the license in Nebraska.
So your employees have to be licensed in several different areas across Kansas, and then they have to get licensed in every state they go to.
Correct.
And if we fix that by licensing them at the state level, all that goes away.
Yep. And then if we can do that reciprocity with other states, that makes it much easier for us to work in those states if our license is counted there.
Okay. Sorry, Senator Dietrich. Keep on.
Hey, thank you, and thank you so much for being here. So usually boards are the licensing authority in our state. What board would that fall under? Do you have any thoughts on that? I know AGC may because they're testifying as well, but.
I'm not 100% sure what board. I know that's the electrical, like your master's and journeyman license. I'm not sure what board that is.
Okay. And may I ask a couple more? So when you get your training to become a licensed electrician, from my experience, and I could be totally wrong, it's primarily through our technical colleges, and is that correct?
That's correct. It's usually a 2-year degree and then a journeyman's test after that, and then hours worked before it becomes effective.
And has this been an issue for our journeyman electricians for as long as you can remember?
Yes.
Okay. Thank you. I appreciate that. And I know AGC is going to testify as well, so maybe we can ferret this out just a little bit more. Thank you.
Senator Ali.
Thank you, Mr. Chair. So if you had to work in one community, metropolitan area, and had to get a license from them,
Yep.
are they reciprocal with other communities, with other municipalities? For instance, if you have a license in Wichita, can you work in Topeka?
You cannot.
So
So
it's
if I work in Topeka and I want to go work in Lawrence, I have to go to a license in Lawrence. If I want to go to Manhattan, I have to go to a license in Manhattan. So
the test
So no,
different?
so the electrical journeyman license is reciprocal across, but the licenses for each area is not. So I would have to buy like a license for Topeka to work in Topeka, and then a license for Lawrence to work in Lawrence. But I believe the journeyman license or the master's license in the state of Kansas will work for any of those.
Sounds like we need to clean up our own space before we go out to the other states. Thank you.
Representative Hoheisel.
Thank you, Mr. Chairman, for the first time today. Thank you for being here. One quick question. You talked about the fees and kind of building off the senator's great question there. You have to get a license if you want to work in Lawrence. If you come down to Wichita, you got to get it. What do those fees look like, the licensing fee? I mean, how much money are we talking in added additional overhead by having to apply and get all these licenses in all these local communities?
So I didn't actually look at that before, but I know like 15 years ago when I was doing that stuff, I think like the Topeka license was like 25 and Lawrence was 20. So it's not a large amount. It's just the hassle of having to do all and it does add up over time.
Yeah, and I think that's the point is this kind of colluded kind of mess of a framework we have. It just adds unnecessary overhead and
the
unnecessary,
administrative burden.
and the administrative cost on top of the licensing fees. It seems like we can have a more efficient way to do this. So thank you, Mr. Chairman, and thank you for being here again.
Representative King.
Thank you, Mr. Chair. Does this apply to both union and non-union shops as well?
I can't speak to that for sure, but I would say yes.
And are you guys union or non-union?
We are non-union.
Okay. Thank you. Thank you, Mr. Chair.
All right, Representative Wassinger.
Thank you, Mr. Chair. So what I'm hearing is that if you want to help someone with you're an electrician and you want to help someone in another town, say a child or anything like that, you're just doing it without being inspected and you don't get a license. So it's all we're just forcing everyone to kind of go under the radar.
I would say that's accurate. I don't think that's how we operate. We would get that license, but
No, I'm not.
But the door
I'm
is
thinking that
open.
it causes other electricians to just say,
yeah.
okay,
Yeah.
all right. So thank you.
I'm seeing no further questions. Thanks for bringing this to our attention, and we'll work on that this year.
Thank you.
So, all right, so next up, the one, the only, Mike Gibson, with shocking testimony on electricians.
Good morning, ladies and gentlemen, Mr. Chair, committee. As you know, I'm always up here talking about workforce and how it ties back to economic development, which I think this body and your colleagues are very attuned to. That's why Kansas is one of the leading states for economic development. I'm here today in presenting my remarks on contractors licensing in Kansas. Associated General Contractors of Kansas is the Chamber of Commerce for the Kansas construction industry, representing over 300 construction firms and their 20,000 employees, both general contractors, subcontractors, and suppliers, including electrical subcontractors. We strongly support licensing in the state to uphold the safety and ensuring professionals in our industry maintain high standards and integrity. Prior conferee discussed out-of-state and in-state. I think the biggest challenge we're seeing in-state is, as you know, I've reported to you about the shortages of workers. We're making inroads on that, but in the electrical field, there are shortages, significant shortages. In fact, a lot of subcontractors now, because of shortages, are selectively choosing where they're going to do work in the state. Each city and county have their own ability to issue licensing. The question that was asked by Representative Wasinger was about a small community. Some of these small communities do not have the ability to issue license. So I'll leave it at that, in the fact that a lot of Kansas is rural in nature, and those small communities can't afford their own licensing departments. But at the same time, Topeka has their licensing process, Wichita, Olathe, and others that are fortunate enough to have the wherewithal to do so. But they do not recognize the license per se, in terms of the contractor has to go in and apply for the license, and then they can also do the paperwork for continuing education. They have to have CEUs to keep up their license. So there's some redundancy there. There's also additional cost, as some of your colleagues have asked today about additional cost to overhead. In most states, you will see statewide, in my home state of Louisiana, there's a Louisiana Contractors Licensing Board that has worked well over the years. There's other states that have hybrid systems to where they allow for local control, but there's also some state involvement to allow for reciprocity across the board, which obviously that's one of the things that we would advocate looking at from that standpoint. One of our electrical subcontractors echoed when we canvassed all our electrical subs, streamlining the CEU requirements. Johnson County is that facilitator for those type things. They do a really good job, but at the same time, there's certain additional requirements that the contractor has to go through in addition to what the local requires, and that reciprocity would come into play both out of state and in state. Obviously, this improves productivity, obviously reduces the redundancy and overhead cost for the contractor. And again, because there is a shrinking of the workforce, that means also a shrinking of the number of companies. These companies are being very selective of where they do work. And it comes down to how receptive those public agencies are in terms of working to make sure that they be as efficient as possible. I guess conclusion would be Kansas local licensing tradition has served important purposes and reflects the state's commitment to local control. At the same time, experiences like Oklahoma and Texas, who have hybrid systems, lend itself to the state of Kansas looking at how those systems work. Combining statewide credentialing with local enforcement can provide for both consistency and flexibility. While AGC of Kansas does not really take a firm position on a particular structure, we encourage this committee to continue to evaluate how Kansas might improve administrative efficiencies, data transparency, workforce mobility, while maintaining the strong standards that protect our citizens and our industry's reputation. So with that, I stand for questions. I think somebody asked a question about cost. Some of these licenses can run anywhere from $400 to $750, depending on what the particular license is. And when you start adding up the different places around the state that are cities and counties that may have those licenses, that can add up very quickly. Other questions that I could answer?
So, Mike, this isn't unique just to electricians, right? This is almost all the trades that are having the same issue.
It's across the board. I will say, since coming to Kansas 15 years ago, and it's a pleasure to say that I celebrated my 15th year in Kansas this month, that is a recurring concern that I hear across the board for all trades, that some cities have licensing requirements, some don't, and then the recognition of those licenses, and then the additional paperwork that has to come with getting those additional licenses in those cities or counties that require it, and the continuing education that goes along with it too. There's a lot of additional burden of proof of what's going on. And we're not trying to say to you that we don't want the license. Obviously, the license serves its purpose, especially from a safety standpoint. AGC of Kansas members are one of the strongest in the country for safety. In fact, you rarely hear of an accident or a fatality in the state of Kansas, and it bodes well that the fact that they adhere to OSHA standards. And also, as I said to Governor Kelly during the COVID era, we did not have one major outbreak in COVID in the construction industry, and we stayed open, thanks to your help, throughout the entire thing. But because we had already adhered to the OSHA standards for decades, when they added the COVID requirements, it was like a hand-in-glove situation.
Okay, Senator Dietrich.
Thank you, Mr. Chair, and thank you for your presentation. Can I go back and ask you that same question that I asked our previous presenter? If we were to do, I kind of like the hybrid model,
Yes,
state
ma'am.
licenses, but the local enforces, because I like to see that partnership between state and local, right? So do we have an existing agency that would be able to license our journeyman electricians, or would we have to create a new board?
You have a Kansas license of professionals and also Johnson County that is responsible for those areas. I'm not sure you would have to create a new agency, that there's existing ones that could facilitate this. In talking to a lot of the cities and counties and the area of responsibility that those staff have, I think they would welcome having that partnership with the state. That's what I've heard consistently in the fact that there's some things the state brings to the table. For example, the state fire marshal contacted me 6 months ago. He wanted a forum across the state, and he knew AGC was the leading group to do that. We facilitated meetings in Garden City, Topeka, and Wichita for both the home builders and the commercial contractors that I represent. And we had a lot of local officials there that were responsible for the fire codes that wanted to hear what the state fire marshal had to say. And it was a great interaction between local and state officials, because obviously the local has to administer what the state's doing.
Mm-hmm.
And I would suggest the same thing would happen here.
Okay. Thank you, Mr. Chair.
Thank you for facilitating those meetings, by the way. I hear they were quite helpful.
And I want to say this to you. You're the only legislative body, and I was in 3 previous states before coming to Kansas, but I do a lot of interaction with my colleagues around the country. But we had several of your colleagues at those meetings to hear what the state fire marshal had in mind, and what he had in mind was to update, to bring Kansas into the real world on some of the fire code issues that were going on. And I appreciate the heavy lift that he's taking on. But the interest that you and your colleagues showed sent a strong message to the business and industry that were in those meetings. So thank you for that interaction.
Senator Owens.
Thank you, Mr. Chair. Thanks for being here, Mike. So in the contractor world, right, there's an international test that's taken. And then you can take that test result, if you will, and get licensed just about anywhere in the state of Kansas. Are you saying that would that approach work in the, electrical, plumbing, or other areas if there was some type of an international test versus the state trying to take on the entire licensing scheme?
Well, the international, they still have to go into each municipalities to get those licenses. So in that particular case, obviously, that international license serves for a broad form, but still, because each individual city and county that do require the license, they still have to go in there and adhere to those requirements.
Yeah, I'm just always hesitant to think that state level government's the best solution. So I'm just trying to think through this kind of objectively. But I definitely understand the challenge, and I understand the expense associated with going county to county, city by city, obtaining those licenses as well.
Senator, I would also suggest to you, and I've talked to a lot of, obviously, that's my job to talk to general contractors, subs, and suppliers about this situation, and also you, the policymakers. But a lot of contractors, if we could move to streamlining some of this stuff, would not hesitate to pay more to reduce the bureaucracy or the paperwork in multiple jurisdictions. That has been a consistent feedback I've heard from the construction industry, that that additional fee would save countless dollars in the private sector.
Fair point. Well, thank you very much, Mike.
Yes, sir.
Wassinger.
Yeah, this is not a difficult question. I just wondered, do you have to reapply for licenses every year? So it's not just
There
the
is
first time?
There's a periodic time that they have to go back and retest. Fortunately, Johnson County has both. There's a couple components there. There's the code and non-code. The non-code can be satisfied. In fact, AGC has an annual state convention, and we offer several non-code classes that the contractors can attend and get credit, and we have to submit to Johnson County and their board approves those for the non-code, but those contractors have to go over and do the code portion, which runs anywhere from 12 to 24 hours worth of testing.
Every year?
I don't think it's every year. I think there's a period of time there, but it's not. It's like every other year, something of that nature. I can get you that information.
That would be nice. Thank you.
Yes, ma'am.
Thank you, Mr. Chair.
Senator Alley.
Thank you, Mr. Chair. One of the things we've been promoting is our CTE classes.
Yes, sir.
And let's talk about electricians. If you have an electrician going through a CTE class in a community college, they will come out of there with an apprentice license. Or could they come out of there with an apprentice license?
They could qualify for the most part because there's on-the-job training requirements. They would have to go to work for an electrical subcontractor to get that on-the-job training to then apply for the electrical license itself.
Okay. With that apprentice license, if we'll put parentheses around it, could they work in any jurisdiction?
They would be their ability to work in multiple jurisdictions would be limited until they got their formal license in that particular area. For example, if a student, we've got some great examples. We had about 200 electrical technicians that just graduated from Washburn Tech that were fed by Seaman High School and Washburn Rural using the Build Up Kansas funding that you have provided AGC. All 200 were hired, about 150 were hired by Panasonic, and they obviously have them in some areas within their company that may not require an electrical license, but about 50 of them went to work for AGC electrical subcontractors in and around the Topeka area. Those electrical subs took the training that they got at the high school level, transferred into Washburn Technology, and then employed them to get their on-the-job training, and they're in the process of getting their license in order to work in the Topeka marketplace. But they would not be able to go down to Wichita to work until they were able to attain their journeyman's electrical status.
Okay, once they obtain that journeyman's license in the state of Kansas, can they work in any jurisdiction?
They can work in any jurisdiction as long as they comply with the requirements of the city and the county that has those requirements for licensing.
Thank you very much.
Representative Clayton.
Thank you, Mr. Chair. Thank you for being here. So I'm just looking at this and I'm getting a little bit curious here. Under this new standard that you're suggesting, what does enforcement look like?
Well, I think the states that we referenced, Oklahoma and Texas, the local jurisdictions had the responsibility for enforcement. But they, on a statewide basis, they would have some streamlining in terms of the paperwork and applications, things of that nature. But the local control would still remain for the enforcement of the local jurisdictions.
But what about for the smaller communities? I mean, obviously, you've spoken highly of Johnson County, so you're definitely good in my book there. But the thing is that not everyone has those finances available to them. And so those smaller communities, how are they able to enforce?
Well, that would be a challenge. I think that's something that the private sector would be willing to work with both state and local other jurisdictions to be able to transfer that down to the smaller communities. But the smaller communities are challenged, obviously, with financing to be able to do that. And in the states that have hybrids, that's where the state would be able to provide some assistance from that standpoint to help those smaller communities that don't have the departments to oversee it.
Yeah, so I'm just looking at that from an appropriation standpoint, and so just want to have everyone thinking about that. I don't mind it, I just want to make sure that it can be safely implemented.
But again, remember what I said earlier, the industry would be prepared to step up and pay additional fees if we could streamline some of this. So
All of them, like we have a guarantee, or?
well,
I mean, I've been in the business of legislating for a while, and you don't write a check that you can't cash.
I understand that, Representative. The devil's is in the details, but what I'm saying is the industry stands ready to work with the state and local municipalities to work out something that would be a win-win for everybody.
Okay, if we get a guarantee of that money, then heck yeah, put me on. But, until it's guaranteed, I do have to be skeptical.
Well, I think you have seen, for example, Senator Alley asked us back in March for a return on investment of what you've put in to build up Kansas. And when we gave that return on investment, which I believe was about $70+ million on a $2.6 million investment by the state, that's a great example of a public-private partnership. And his response to me was, where can I find a business that I can invest to get that kind of return on investment? But the bottom line being is when you have public-private partnerships, you bring the best of both worlds into not only the administration side of things, but the enforcement based on best practices that the private sector has experienced throughout the state.
Theoretically, yes. Show me the money.
All right, so the fact of the matter is those local jurisdictions are having to deal with it anyway right now, even though they don't have licensure. They have to monitor electricians in the middle. Right, so either way, they're going to have to do it.
Yes, sir.
Representative King.
Thank you, Mr. Chair. Mike, how do you handle common licensures when different cities, different counties around the state have different building codes? Some have different versions of the UBC or the IBC. So how do you work with that?
Well, again, that is one of those untold, not a secret, but it's an untold burden on the private sector to work through those challenges. That's one of the things that why when the fire marshal, state fire marshal contacted me and said, hey, would you be willing to facilitate some meetings around the state? He's looking at trying to bring all of that into a standardized process, which again would benefit not only the private sector, but benefit the state of Kansas, because again, as you heard in a former testimony, a lot of states that come into Kansas start dealing with all these different moving parts, and they're not accustomed, they're looking at streamlining in their own respective states. And the more that we can standardize some of these building codes and fire codes and things of that nature, the more receptive we're going to see in terms of inviting new industry and business to come to Kansas.
Thank you, Mr. Chair.
I, for one, would welcome something like that because one of my past lives was in small construction, and we're over engineering a lot of things because of local business, local codes. And
Yes,
if we could, we'd save a lot of money for a lot of people if we could streamline the building codes and stop over engineering things.
I'd be glad to champion that if you
bring it.
And AGC of Kansas stands ready. We would provide subject matter experts. We could reach out to both the engineering, architectural, and construction industry to bring subject matter experts to the table to work with a task force with the state. My past experience in 3 other states, that's how they've been able to address some of these things, by bringing in those subject matter experts from the private sector to interact with policymakers to see what makes the most sense, and to address the comments about the money. Show me the money. how to get the most bang for your buck to where, and also reduce the redundancy and the burdens that go along with a project. I know everybody gets excited when there's an announcement of a new project coming to the state or coming to a community, but the downstream in terms of how to actually get the project done sometimes become an inhibitor of moving that project forward.
All right, so I'm not up. Senator Faustido.
Thank you, Mr. Chairman. So Michael Gibson, you're all right in my books too, because you mentioned Wichita and Sedgwick County, so that's 2 for 2. So you mentioned redundancy.
Yes,
so in your presentation, you said that you have to have that continued education to certify in both jurisdictions. So certification of 24 hours versus the 12. So how would that look to you? So I guess I'm asking, are you the 24-hour period or the 12 in both areas? Is it different information that you're being educated on, or how does that look?
Each jurisdiction has their own requirements. And again, we like what Johnson County does in terms of oversight. There is some challenges there that we would like to explore with their board of how to make it, especially if you've got a company like the one that just stood before you that's been in business for a long, long time. For them to keep going through some of those processes, there seems to be a way that you could grandfather or recognize past performance and past testing to bypass that. Now, if you're a startup company, obviously you need to prove yourself. But those hours that are required are there and vary depending on the agency that's overseeing those things. But the recognition of those CEUs are not, there's not reciprocity between the counties and cities across the state.
I think it's also a problem in education too. So if they end up in a certificate from your great program, that doesn't always transfer into a community college or a trade school, and we need to work on that this year to allow that to count as hours earned in a classroom.
Well, but let me state for the record on that. All of the training that is received at the high school level with the National Center for Construction Education Research Curriculum, which I've shared with all of you, the NCCR, those credentials are transferred to the community college and vo-tech colleges. That's the beauty of the NCCR curriculum. It is a standardized process, so wherever they leave off at Washburn Rural High School, they can pick up at Washburn Tech. Oh, by the way, I'll save this. I wanted to save this for next session. I was just at Kansas State and Pittsburgh State in the last 2 weeks at their advisory council. Nearly 25% of their new enrollee construction science students came out of the Build Up Kansas high school programs. We are now, as I told you, you start stimulating the younger generation in terms of what value technical training means. They are now taking the next step, and we had record enrollment, freshman enrollment in construction technology and construction science at both Kansas State and Pittsburgh State in the fall of 2025. And 25% of those enrollees came through the high school CTE Build Up Kansas program. So not all of them are going to college, but we're getting kids that are now seeing the value of a technical trade, but they want to go farther. And Kansas State and Pittsburgh State, in fact, now the biggest challenge those two schools have is space and instructors. That's a good problem to have.
Representative Clayton.
What do most of the graduates from the Build Up Kansas program, what is their starting wage?
In the information that we provided in a return on investment to Senator Alley, and thank you, sir, for asking for that information, started at about $54,000.
$54,000 a year
Yes,
for a
sir.
starting
Yes, ma'am.
wage?
And that doesn't include overtime. I'll just remind you, when you all start talking about high wage and high demand jobs, and by the way, that's 18, 19, 20-year-olds that are starting at that wage, that You're not going to find a lot of industries that can step up and do those things. But again, it's supply and demand. Ladies and gentlemen, I told you 3 or 4 years ago, we need 58,000 new construction workers. That demand is as high as it has ever been in this country. And if our folks can't find the people, they're out of business. So anyway, oh, by the way, I'll share with you too, you asked about the Build Up Kansas wage scales. Last week, Kansas State, their graduates in construction science, their starting salary is $76,000. $76,000 for college graduates coming out of construction science. They just reported that at their advisory council meeting in Manhattan last Friday. The highest it's ever been. And by the way, 90% of those graduates are staying in the state of Kansas. Versus 15 years ago, only 25% were staying in the state of Kansas. Major, major inroads, ladies and gentlemen, and it's you, the leaders, are making that happen.
All right, Mike, so we're a little bit ahead of schedule, which is not normally the case when you're here. But you do such a great job, and I always love having you here because you're so dynamic. And I'm going to give you 5 to 10 minutes to talk about the Build Up Kansas program and the progress that you have made over the last couple of years, just because it's such a great program. And then I'm going to ask, Monday, we are having a meeting on return on investment. And so your presentation that you made, if you can't be here personally, maybe you could submit it written only so that we could review that, because that's, it was like you said, it was a $2.5 million or $3 million appropriation that we made. And the return on investment is pretty incredible when you compare it to some of the other incentive programs that we have out there.
Well, the thing that I said to you, and again, I didn't start talking about this a few years ago. I started before your committee and others 8, 9, 10 years ago. The states that figure out how to deal with technical training are the states that are going to continue to get their lion's share of economic development. And I think Kansas is proving that to be true. In fact, I've been asked to go all over the country, do a presentation. There's not another program like Build Up Kansas in the country. And that's not me saying that. That's Pearson, who is the largest publisher of textbooks in the country, who does the publication for NCCR curriculum. We had a record number of textbooks sold in August of this year. Over $500,000 of textbooks were distributed just in that month to high schools across the state. We're approaching right at 9,000 students that are enrolled in high school CTE programming. 3 years ago, we only had 2,000. These students are moving to it, and the reason for that is the instructors. We now have a standardized training process for those instructors. There's a two-day program that they have to go through, a train-the-trainer process. They are now excited because some industry has stepped up to help them with their technical skills, to where you've heard me affectionately say this, and my legislative consultant, Scott Snyder, doesn't like me to use this analogy, but our instructors are no longer teaching birdhouse building. They're actually teaching finished carpentry and HVAC and welding. But the reason they were teaching birdhouse building is because they didn't have a go-to industry or a go-to curriculum. They now have that. But guess what that's done? That's gotten the instructors excited to be our champions, to get their young women and men enrolled into their classroom. By the way, nearly 21% of the enrollees are female. I told this story to the chairman. In fact, I introduced you to the young lady out of Osage City High School last fall at our construction event here in Topeka. This young lady was a junior at Osage City High School, did not know what she was going to do, said she was not going to go to college, and her friend said, "I'm in Mr. Smith's carpentry program here at the school. You ought to get into it." So she took a chance. She got her credentialing with NCCR. And, oh, by the way, she looked over on the Build Up Kansas landing page, which has a 2-minute video on Pittsburgh State, Kansas State, and Fort Hays State construction programs. She looked at Pittsburgh State. She got a scholarship from AGC. She graduated 2 years ago with a construction program, or construction degree. She's working for KBS Constructors here in Topeka as a project engineer. She's making nearly $90,000 a year. Oh, by the way, that $90,000 is tax money that you can reinvest in healthcare, education, infrastructure. Those stories are being replicated all over the state. I introduced that young lady to Chairman Tarwater. He looked at me and said, "You told me if we partnered with you, these things would happen." They're happening at a rapid pace, ladies and gentlemen. These are not minimum wage jobs. They're great careers. Like I said, we had scholarship interviews yesterday. AGC gives over $100,000 in scholarships to Kansas State, Pittsburgh State, and Fort Hays State. We interviewed students yesterday at Kansas State in Manhattan. It was so great to sit in that room with them. But 90 of the 15, 14 said, "I've got job offers, and in the next year, I'm staying in the state of Kansas." Now, some of them preface, it's Kansas City, and we consider Kansas City, whether it be Missouri or Kansas, still in the state. And I have to agree with them on that. But the fact is, we're right at about 125 high schools across the state. What is my biggest challenge? How do I get to 298 high schools? The biggest challenge is finding instructors. But we are giving the schools the opportunity to post their jobs on the HR platform that is provided with Build Up Kansas. We've actually connected about 12 construction retirees to go back to the school that they live close to teach the CTE programs. So we're doing our part. Oh, by the way, Build Up Kansas is not part of the correctional facilities. AGC does that on its own. We have 4 correctional facilities. The largest is at El Dorado Correctional Facility. We have about 125 low-risk inmates taking masonry training. Last year, I was approached by Junction City Chamber of Commerce to work with Cloud County Community College to develop an assessment program for military that are coming off the base that have some construction skills, but we need to assess what level. And we're going to do remediation to get them up to speed to where they can stay in the state and go to work for a local contractor. That is what you have done in partnering with the private sector. I said to this group several years ago, and I was told that was a bold statement. I think it was Dan Hawkins that told me that. I said, "You've got a partner that cannot fail." Why? Because we need 58,000 construction workers. If we fail you, I'm going to have a lot of general contractors and subs going out of business. That's not going to happen, ladies and gentlemen. This is an easy fix. But the biggest challenge right now we have is helping the rural communities find those instructors. I was just out in Hays last week. I've got a great staff, but some of my contractors want me to be there firsthand. But a school that one of my largest mechanical contractor in the state graduated from about 40 years ago, Joe Glassman Corporation. And he wanted his school to get up and running with Build Up Kansas. His principal was so excited. His instructor was so excited. They just started a carpentry program in the basement of their school, but they needed to get their instructor in the trainer. Your funds are helping make that happen. But the word is out. Oh, by the way, the Kansas Department of Education earlier this year in January, amongst all their educators, the #1 pathway in the Kansas Department of Education is construction technology. The question was asked by department heads, why is this groundswell happening that construction technology has risen to the top in the high schools? Several of our champion instructors stood up and said, as AGC's Build Up Kansas with the help of the legislature. So that, in a nutshell, is where we're at. We are seeing, we've had over 2.5 million landing page hits. We geofence every school. If you don't know what geofencing is, go to Dillon's tonight. You get a pop-up on your phone. You get $1 off your bread or milk. That grocery store has been geofenced by that vendor. We geofence every high school that's participating in Build Up Kansas. The parents are now starting to tell their parents, if your son or daughter doesn't know what to do, get involved in the CTE program. By the way, Build Up Kansas is being utilized by the instructors at their parent-teacher night to show the parents, this is why your son or daughter is in my carpentry program or welding program. That is powerful. I can't put a price tag on our return on investment on those type things. But that's what's happening across the state of Kansas. I was just in a meeting with my colleagues in South Dakota 2 weeks ago, and they said, how the heck did y'all do all this? I said, we started this journey about 25 years ago, but if it wasn't for our Kansas legislature and our visionaries with our policymakers, we wouldn't be where we are today. By the way, NCCR is the largest construction trade materials in the country, 9,000 education entities. Earlier this year, we got a letter from the NCCR. I made a bold prediction 4 years ago. The chairman knows I like to make bold predictions. But I made a comment 4 years ago on the National NCCR Workforce Committee that AGC and Build Up Kansas was going to be the #1 customer of NCCR. We got a letter earlier this year. We're number 4 out of 9,000 education entities in the country. Number 4. You did that by helping us move the ball forward. Number 4 in less than 3 years. We're not stopping. We're not stopping until we help every high school and community college get to where they need to be, giving these technical skills, giving a life skill to this younger generation, which we're already seeing. I will promise you, in the next census, we're going to start to see population growth in this state. I will assure you, because those kids are not going to go to Houston and Dallas. They're going to stay in Kansas. They're going to meet their future spouse. They're going to start a family here. And oh, by the way, mom and dad won't have a reason to move to Houston to follow their kids and their grandkids and take their wealth out of Kansas. That's what you have done. That's what the power of technical skills that no other industry can bring to the table. There's no other industry in this state that can support economic development. I'm talking about new economic development than construction. So I guess I need to shut up.
Yeah. Well, we could listen to you all day, but time is up, and I really appreciate you taking the time to go through that.
Thank you for your leadership. And again, we're here as a resource. Use us. If you're in district and you need somebody to come out and echo what you have done to help move the ball forward regarding technical training to help your constituents and help their kids, give me a call. I'll be out there shoulder to shoulder with you, or one of my staffers will be there shoulder to shoulder with you. Oh, by the way, and I hate to put him on the spot because it's not a conflict of interest, I can promise you that. I hired him 2 years ago, and he asked me if he could run for state senate last year. But Brad Starnes is now, he is a Build Up Kansas staffer. Why do I have him? Because he's a retired superintendent, and he can talk superintendent language. And that's his purpose. That's his only purpose, is to talk to superintendents about the value of CTE program. And that gentleman has paid back in spades in terms of the investment, because those superintendents, they know he's walked in his shoes or their shoes. And that's powerful, very powerful. Just like I have the best CTE director who retired from USD 259 and PJ Riley. He can speak CTE director language. I can talk it, but I didn't walk it.
Hey, Mike, your time is still up.
I know it. Thank you.
And unfortunately, Charles has to follow that. Next up is a briefing on SB 30 from Charles Reimer. And this is the bill that the House passed after conference committee, but the Senate had already adjourned for the year, and so it's still kind of on the docket, and I figured we'd get an update on that since it has to do with licensing and regulations. So,
yes, Chairman, members of the committee. So SB 30, as Eric mentioned a little bit earlier today, basically includes the provisions of Senate Bill 229 as amended by the Senate committee, which, as the chairman indicated, pertains to legislative review and approval of occupational license regulations. There's really almost no difference between the provisions of the underlying bill, SB 229, and this conference committee report in Senate Bill 30, except replacement of the term assign and assignment at page 6, line 1 and line 6 of the bill, with request and such request at page 3 and 4 of the CCR. So that's basically about the only change. As the chairman mentioned, it was the conference committee report was adopted by the House 86-38. No action was taken by the Senate. I'd note the underlying bill, Senate Bill 229, as amended by the Senate Conference Committee, was passed by the Senate 31-9 in March 2025, and referred to the House Commerce Committee just a few days later. The gist of the bill is that any new occupational license or material change, and that's a defined term, to an existing occupational license adopted by an agency, and an agency is also defined, on and after the effective date of the CCR would require approval of the legislature by a joint resolution before the new license or material change would become effective. Unless the legislature had already ratified the new license or material change by enactment of a bill pursuant to the provisions of KSA 77-441. And as the committee may recall, that was the change back in 2024 HB 2648 that provided that if the economic impact statement of a regulation would indicate that compliance cost, implementation and compliance costs would equal or exceed $1 million within 5 years of adoption of the regulation, then the regulation would require approval by the legislature through enactment of a bill. The CCR also sets forth a process for review by the legislature of these occupational license new regulations or material change to existing regulations, including referral to the relevant standing committees of each chamber, a report presentation by the legislative research staff, as Eric also noted, to each such committee, and a written recommendation as to approval or denial of the proposed new or materially changed license regulation by each such committee to the legislature before the legislature takes up a joint resolution. The CCR also creates a new reporting requirement for agencies due in September of each year to the Joint Committee on Administrative Rules and Regulations. Part of that reporting requirement is that agencies would be required to list all occupational licenses over which the agency has jurisdiction and provide specified information for each license. So, turning to the CCR, the first section, the definitions. Agency is defined as any department, bureau, division, board, authority, agency, commission, or institution of the state. Certain agencies that regulate healthcare are excluded, specifically including the Behavioral Sciences Regulatory Board, Board of Examiners and Optometry, Board of Nursing, Kansas Dental Board, State Board of Healing Arts, and State Board of Pharmacy. The State Board of Technical Professions is also excluded. There is a definition for material change. I refer you to my written brief for that unless you'd like me to state it out. Occupational license is also defined in the CCR. The Section 2 pertains to the annual reporting requirement. As I mentioned, each September, each agency as defined in the CCR is to provide a report, and that report, in addition to a list of each occupational license in the agency's jurisdiction, also includes a number of other things, number of current licensees, description of typical employment of such licensees, list of the regulations governing issuance and maintenance of the license, authorizing and implementing statutes, whether the license is federally required or regulated, a description of the educational, training, and testing requirements to obtain and maintain the license, total agency fees, an identification of any requirements of good moral character, licensing restrictions based on criminal records or criminal history, and also a description of any reciprocity agreements allowing interstate license recognition. Section 3 is, I guess, really the heart of the bill that establishes that new requirement of legislative approval by joint resolution, and just sets out the procedure for how that happens. As I mentioned, the standing committees that customarily consider legislation pertaining to the applicable subject matter are to review and provide a report to the legislature as a whole, and legislative research staff provides a report. And there are specific listed requirements for that report by legislative research staff to the respective standing committee. Those requirements include analysis as to the necessity of the new license or material change to the existing license to protect the public health, safety, or welfare. And I would note that welfare is also a defined term. It's specifically defined as protection of the public against fraud or physical or psychological harm. It does not specifically include protection of business or public or private agencies against competition. Another factor that must be examined by legislative research staff is available alternative measures, including any potentially less restrictive measures, analysis of whether the new license or material change is the least restrictive means to achieve the stated purpose, examination and comparison of whether and how other states regulate that profession, examination of any effect on job creation or retention, examination of costs and benefits, and that is to include specifically estimated compliance and opportunity costs, and that would include licensing fees, education costs, experience requirements, estimation of total days time required to get that license, estimated secondary or indirect costs, and estimated effect on state expenditures, including administrative expenses. And then, as I noted, upon review of that report by staff, the committee provides a written recommendation regarding approval or denial to the Speaker of the House or the Senate President, as applicable, and then that recommendation is distributed to the legislature for consideration before acting on any joint resolution. And that is what the CCR does. That is, currently is in the Senate.
Okay, so the gist of it is we don't want the departments to create new licensure, overburden some licensing unless we weigh in on it. And that's kind of the gist of the bill. There's a section of the bill that has a role for KLRD that might be overreaching that Eric is going to comment on here in a minute, that we're going to maybe have to make a change to the bill before we pass it next session. So Eric, you want to?
Sure. Thank you, Mr. Chair. So KLRD is neutral in terms of our role in the process and our ability to provide information regarding the licensure requirements. But we would just note that we have some concerns about language that asks us to provide policy positions, because that's outside of the purview of what KLRD is, what the purview of KLRD is in terms of its service to the legislature. And then we would also note that it would just, there's a potential fiscal impact in terms of requiring additional personnel potentially. And we would also be more than happy to take a deeper look at this and provide further information if we have any additional comments.
So specifically, what is it in the bill that has you weigh in on a policy?
I think we would want to look at that a little bit more, but just on the surface level, I can't speak to the specifics for the department, but on the surface, it looks like examination of alternative measures potentially gets into biases about what would be, a better way to do something or a less restrictive way to do something. Those are kind of subjective determinations and things along those lines.
Okay, so Charles, if we were to realize that we need to make a change to that bill, what would the process be? Would the Senate just send that back to committee and then we would re-meet on it for conference committee? Or, well, it's a CCR, so we've already voted on it and passed it over to the Senate.
Chairman, I would want to check on that. I think that's a pretty technical question, so I'd like to check on that, and if it's all right, get back to the committee after lunch.
Any questions on SB 30? Senator Falscadeau.
So, Mr. Chairman, to your question there and your point, so the state agencies, have they weighed in on the legislation? You said we've already concurred on it, but in the House or conference committee, but so did they give input, and how would it affect each? I know I'm sitting by the chair of the Joint Rules and Regs Committee, but how was that piece kind of ironed out in Senate Bill 30?
This is something that was just brought to my attention when we were going to do a review of the bill, since we were talking about rules and regulations and licensure in this meeting. I asked for a review of SB 30, and it was brought up at that point that, hey, there might be a conflict with the KLRD having to weigh in on policy, and they're not really supposed to do that. So, any other questions on that? All right. Seeing none, we'll move on. Okay, we're a little bit ahead of schedule still.
Lunch is here.
Lunch is here. Lunch is here, and it's provided by Americans for Prosperity, and thanks for that. You guys can grab a lunch, and we'll come back at 12:20.
And if you don't believe America should
All right, everybody, let's get back to work here. During the break, it was pointed out to me that the agencies that have licensing authority are all fee-funded, and they're not funded out of the SGF, so we don't have to worry about that. And each year in appropriations, we review all the budgets for all the fee-funded agencies, and if they're good enough, then we don't allow them to adjust the rates. But if they need more money, we allow them to adjust the rates. And so, if anything, any kind of recommendation that we make later today affects a fee-funded agency, they'll come to the Appropriations Committee for the appropriate time, and we'll move on from there. Clay Barker is up next. Regulations and legislative considerations. And so everybody pay attention. This guy knows what he's talking about. Clay, thanks. Thanks for coming.
Mr. Chair. Mr. Chair, members of the committee, I'm Clay Barker, the General Counsel for the Kansas Secretary of State, and I'm here to talk about the regulations process. And I'll just segue into that from your last topic, SB 30. Our office had some background role in working that bill last session. And I recall we couldn't figure out at the beginning how the building trades were licensed in Kansas, as they didn't seem to have any state issue. And I was actually, it sounds like a bad joke, but in a bar in Goodland, Kansas at a VFW, ran into an HVAC contractor from Johnson County, asked her, and got an earful on it. So that's a very expansive issue. You heard a lot of it this morning already. But occupational licenses is an issue that probably needs to be looked at. But I'm going to go to my main topic, which is the regulation process. So first of all, I'm here on behalf of the Secretary of State, but I have talked to many agencies that issue regulations. There's 116 that have authority to do it in Kansas. I've worked closely with the other main agencies that work the process of getting regulations through. I've personally written regulations and got it through the process for everything from elections to notaries to business. Currently, we have a package of regulations on fees. We're trying to reduce most of the fees our agency charges, and it's gone to Department of Administration, to the Attorney General, back to the beginning, Department of Administration, now it's at the Attorney General again, and eventually it'll get through. My presentation will be in three parts. First, I'll summarize the current status of the process. Then I'll identify some problems or challenges, 3 of them, and then some proposals. Some are just on drafting statutes, which really can't be in a law, and some are possible legislative changes. So first of all, the current process in Kansas. 25 statutes govern the process of adopting a regulation from start to finish. And again, 116 agencies have authority to do it. Regulations were first brought into Kansas in 1939. The last time there was a major overhaul of the process was in 1965. If you're curious, there's about 29,000 statutes in Kansas and north of 9,000 regulations. Again, some of those could be one sentence to multiple pages, but that gives you a feel for it. Depending on what outside group you look at, and they have different ways, different metrics of measuring it, Kansas is either the 4th least regulated state to the 20th least regulated state. So we're on the lower regulation end of the spectrum. And again, different groups have different ways of measuring this: cost, action words, occupational licensing, things like that, the burden. On Exhibit 1 that I put in my testimony, and it's the colored one with some charts. This was done by KLRD last year for the Efficiency Committee. And I think it shows that since the 1980s, the trend has been fewer and fewer new regulations amended or revoked in Kansas over time, with a big drop-off in 2010, which I think is a good sign. And the process that Kansas uses, that it's chosen to use, is very decentralized. There is no one agency in charge of regulations. It's the Department of Administration, the Attorney General, Department of the Budget, Secretary of State, plus the agency that writes it. And no one has overall control of it. No one has total data of what regulations started, following it all the way through to the end. And because of that lack of unity of command or coordination, it has probably hindered the modernization of the process over time. And I'd also like to point out that the Kansas system is different than the federal system. So when I hear people talk about prairie chickens, I always have a little exclamation point pop up. That's a federal regulation. It's not a state one. And I'd also like to point out that businesses tend to have a love-hate relationship with regulations. They don't like being told what to do, like most Americans. Sometimes they don't like what the regulation is telling them to do, and that's when you get things like those unelected bureaucrats are off the rails again. But most businesses prefer to have objective, clear standards. So if a statute says be reasonably safe, they want to know what that means, and the regulation can fill out the exact standards they have to meet. I will now go over quickly the process, which is the second exhibit, which is a very complicated flow chart on our webpage, but basically there are 8 steps. First of all, the legislature must authorize the agency to adopt a regulation. That is, the legislature delegating its legislative power to an executive branch office, and the legislature can limit that grant in any way it sees fit. That is the grant of authority. But once the authority is granted in a law, the legislature can't pull it back unless it passes another law, which means both chambers and the governor or supermajority in both chambers. Then the state agencies drafts the regulation. And unlike laws where you have professional revisers who are experts in this, most agencies don't have anyone who's an expert in regulation. Some of the bigger agencies like KDHE or Department of Ag do have someone, but you don't have experts in regulations, which is why these other groups like Department of Administration and the AG help them out. It then goes to Department of Administration, which makes sure the regulation is properly formatted, it's written in clear English, it's punctuated correctly, and often the regulation, draft regulation, will bounce back and forth 2 or 3 times as it's marked up and fixed. The Department of Administration cannot fix a regulation. It has to send it back to the author to make the changes. It can only circle or highlight what needs to be changed. It then goes to the Attorney General once the Department of Administration puts an ink stamp on it, approved. And the Attorney General must furnish an opinion on the legality of the proposed legislation or proposed regulation. That means the Attorney General's job is to make sure the regulation is consistent with what the statute told the agency to do. And the Attorney General will look at the entire regulation and every statute involved, even if parts of the regulation haven't changed, to make sure. And my last understanding, and I think Mr. Hutchison will be here this afternoon, but they have 2 separate attorneys review it independently to make sure. If it's approved by the Attorney General, it'll go on to the Department of Budget that looks at the the economic impact statement, which looks at generally the cost and burden of the regulation. And they'll make sure the analysis of the cost is reasonable, plausible, it makes sense. It'll then move on, if it gets the rubber stamp from the Department of Budget, to 2 outside comments. One is from JCAR, the Joint Committee on Administrative Rules and Regulations, which is obviously a legislative committee. I know some of you are on it. For most of state government, if you haven't learned this already, JCAR is known as a hot committee, meaning you better go in there with a flak vest and a helmet and hope you can sit down when you're done, because you will get a lot of good feedback. And the other comment is, once the regulation is open for comment, there's a 60-day period where the public can actually see it for the first time, make comment, or go to a public hearing, which has to occur, and give input to the agency. And then the last step, it arrives at the Secretary of State. We make sure everything was done properly, stamps, and then we will put it on the Kansas Register, and then it's formally adopted and it goes online and people can actually see the input. Moving on to some 2 recent, I think, very positive improvements to the process. One was, back in 2022, the legislature allowed the Secretary of State, or got rid of books for regulations, and it's all online. So if you happen to have an old KAR set in your office, you can throw it out. And that was important because before that, the official regulation, you'd have to look in a base volume, an annual supplement, and then the Kansas Register to see if anything new came out. Now, what is online is the official version. And it's free, easily searchable, cut and paste. You can link to it. It's after we made the change, not a single complaint from anyone that it's now in one place and everyone can access the regulation and know what it is. The second was the 5-year review process, which was now KSA 77440. That requires every agency that's issued a regulation once every 5 years, so they're broken up into groups of about 23 agencies. They have to submit it's on a big spreadsheet with the columns, but they certify that that regulation is necessary, beneficial for continual operations, that it's necessary for the public. And when you tell an agency, they have to certify that. Someone is putting their name on the line that that regulation is there. Agencies will sit down and actually go through every regulation line by line and debate whether it's needed or should be changed. And because of that, we've seen a surge of revoked regulations, because agencies will find regulations that no longer serve a purpose. They didn't hurt anybody, but they shouldn't be there. and amended regulations, because they'll look at it and go, you know, we really should update that one as long as we're doing it. And I think that 5-year review has been very beneficial to the state, going through the regulations. We've gone through 3 iterations of it. There's 2 more coming. In my testimony, I showed how in the 3 years before this bill went into effect, there was a certain number of revoked regulations. In the 3 years after, that has jumped up 400%. And that's agencies grinding through their regulations and getting them updated or revoked. And because a lot of the agencies don't have expertise, both the Secretary of State has put out a toolkit, which is forms and process to try to guide other agencies or boards through this process. And the Department of Administration has put out an actual manual. It's online, but it's a manual of how to write regulations and go through the process to help people. The public has only 3 times when they can actually see what the regulation is before it's adopted. And that's, well, let me back up. The public has access to the regulation in 3 ways, is a better way to say it. First, they can view it online, search it, review it, study it. They can sign up for a subscription service where anytime a regulation is open for public comment, they get an email. It isn't for specific agencies, but you're told this regulation is now open, here's a copy of it, here's where the public hearing is going to be, send your stuff in. And they can also get, and I put on Exhibit 4 if you're curious, a list of the current regulations that are open for public comment. And the one problem with that for the public comment, and I'll just having experienced this, is sometimes you go through the regulation process, Department of Administration, AG, budget, you're getting pressure to get the regulation out. It's gone back and forth for 6 months, 8 months, a year. You get to the very end of the process. You can see the light at the end of the tunnel when the regulation is going to be adopted. And someone at a public hearing brings up a good point. It's not a major point. You think we probably should do that, but I've got to get this regulation adopted so we can implement the statute. Then you circle back, and the next year you amend your regulation with these ideas. It's almost as if the public input comes too late in the process, and we have a proposal on that. We do have one future process improvement, and my colleague Whitney Temple is in charge of it, is without changing any of the laws, the steps in this process, we will be putting the entire process online. Right now, it hasn't changed since 1965. It's paper that's run around between agencies with ink stamps on it. You have variation problems, spilled coffee, lost pages, and this is being done with grant money and fee money, so there's no SGF involved, but we have a contract with a company called Esper, which has done this for many other states. It will allow data to be gathered on where regulations are, and Senator Tyson answered your question before comment. You'll be able to see when a regulation was submitted originally. So you can tell if somebody's taken too long to draft it, and then is it in the process or are they dragging their feet? It'll be public to see where it is. And hopefully that'll help speed things up if needed. Now, moving on to 3 problems we've heard about with the process, and probably the first one is one you're all familiar with, and that is the statute and the regulation do not align. And it's just basic law and common sense that a regulation needs to be consistent with the statute that authorized it. No new requirements. You don't expand powers of the agency. You don't impose obligations the legislature didn't intend. That regulations are supposed to implement statutes, provide details and process, not create new things beyond the legislative intent. And it needs to be reasonably aligned with what the legislature was doing. If they were trying to make a process easier, you can't have the regulations make it harder. And I think part of the reason this occurs is difference in perspective. The legislature, if you want to think of yourselves at the top of the mountain, you all represent different districts, you have different input, different background, you hear from all the different constituencies, you pass a law. It goes down to the regulator, and they're at the bottom. They see their niche area, and that's all they know. And so they regulate based on that. And to exaggerate for effect, if the Agency of Car Safety was told to put out regs for the safest car possible, it would look like a tank. But that's not what the legislature would have intended. I think part of it is a different perspective. Part of it can come from the statutory grant of authority is unclear on its limits. And it could be that an agency is taking advantage of a broad grant of authority and it can go too far. Why would a regulation, once it's drafted and adopted, be too expansive or not aligned with the legislature? And I can only see 2 reasons. Either the granting language was not restrictive enough, or the Attorney General didn't do their job in making sure the regulation aligned with the statute. And I can assure you, I've worked with the Attorney General. They are very thorough in their analysis. Long checklists. They come over and talk to you about what they found. They ask questions. Again, I think it's 2 separate lawyers have to give an opinion. And I'm going to have some suggestions at the end about maybe some ideas on drafting. The second problem comes with the inherent difficulty of weighing cost versus benefit. It's fairly easy to make a good faith estimate of the implementation cost of a regulation, what new equipment, what new people we need. It's more difficult to do benefits because a lot of those are subjective, and it's really difficult to measure the real cost of a regulation, which is opportunity cost, what houses aren't built, what businesses aren't established, what things aren't done. And that's a difficult weighing that's really better suited for the legislature than a regulator, because it's subjective. Is it cost or speed? Is it cost or safety? You have to weigh those things and come up with a middle ground. And I know we heard some testimony yesterday about stairways in apartments and how wide they need to be. An example that's often given in regulation podcasts, there are such things if you listen to them, is size of elevators in, say, a hotel. One theory is it needs to be big enough for someone with a wheelchair and the person behind them, which would be a smaller elevator. Others will say, no, it needs to be big enough for an ambulance gurney, a stretcher. So if someone gets sick or injured, you can get the stretcher in the elevator, get them on, and roll them off. That would be 2 standards. Obviously, the bigger one is a lot more expensive. So it's a weighing of cost versus safety. And the regulators may veer one way or the other, depending on who's doing it. And the third problem is, and most agencies think this, it takes too long. Our process, many states, it takes 4 months to get a regulation from start to finish through. In Kansas, I don't have an answer, but it's 6 months to a year often. And I don't have an easy solution to that, but it would help agencies implement statutes quicker if they could get the regulation through faster. Okay, now I'll turn to my proposals. And again, they're in 2 groups. One is just drafting suggestions, and the other is some possible legislation. So first on the drafting, and this is the #1 recommendation from agencies across the state. You talk to anyone, they'll bring this up, is they'll say, please give us tight authority, restrict our authority on what you can do. Tell us what you want this regulation to do. And an example is one in Notaries Public. It lists out 11, in the statute on regulations, lists out 11 specific narrow areas. Regulate this, regulate this, regulate that. Then there's 2 provisions at the end that say that limit the discretion. And you must be consistent with this, and you must be consistent with that. And that gives the Attorney General specific guidance on how to make sure the agency didn't go too far when it regulated notaries. An issue that comes up with the word shall, and shows when the legislature says you shall issue regulations, it would help if you indicated shall issue regulations on what. Sometimes the what is so general, it doesn't give the agency good guidance on what piece you think as legislators needs to be regulated. It's just anything you want, may, shall. An issue that Senator Tyson brought up this morning is there are times when an agency is told you shall issue a regulation, and the agency looks at it and can't think of anything to regulate, and they're caught in a bind. They know legislators generally don't like regulations, but they're told to regulate it. And they'll have lawyers look at it, they'll talk to the AG, and they just sometimes can't figure out what to regulate. And every year, KLRD will send us a letter saying you haven't passed your regulation yet, and we'll politely say, we know that, but we can't think of anything to regulate. Because a regulation cannot restate a statute, and it can't tell a sister agency what to do. It's only the public and people below. And so the recommendation there would be to tighten up the grant of authority, to make it more specific. The other way of doing it is how some states do it and how the legislature has given it to the insurance commissioner, who has the authority, shall be specifically authorized to adopt such rules and regulations as are reasonable and necessary to carry out the provisions of the Act. Very broad grant of authority. Okay, a second recommendation on drafting is don't use adopt by dates. Sometimes a statute is passed, it's enacted in May or June, and it will say adopt a regulation by July. The agency doesn't control when the regulation's adopted. It has to go through a multi-step process. So you put the date in there, and sometimes the agency can comply with it, sometimes it does best efforts and it can't. A third would be careful of ambiguous drafting, and I gave an example in my testimony of a grant of authority that didn't use may or shall, and it was confusing, and it ended up in a lawsuit, which then froze the regulation moving forward for several months. And I would also urge the legislature to not use metrics that are susceptible to gamesmanship. For instance, you'll hear some people say, we're going to pass a law that says for every new regulation issued, you have to get rid of 3. Well, all that's going to do is make your regulations, you may have fewer of them, but they're going to get a lot longer. You're going to pack the same content into fewer numbered regulations. Another one is setting dollar amounts. If the cost is above X, it triggers a whole bunch of processes. Now, that may be useful, but it has some inherent problems. First of all, the amount's often arbitrary. Second, the agency is able to plausibly estimate a higher or lower amount depending on what it wants. If it wants to avoid the trigger, it estimates low. If it wants to kick in the trigger and maybe delay implementation, it can estimate high. Also, there was a problem with determining whether the cost comes from the law, the underlying law, or the regulation. If the law says build a house and the regulation says paint it green, is the regulation responsible for the cost of the house? It's hard to break that up. And another game that I've seen in other states is if there's a dollar limit on the burden, is to simply break the burden up into multiple regulations that are filed at staggered time periods. Like once a month you put one regulation in, a month later another one. I mean, there are ways of getting around dollar amounts. Even though I understand the legislature's intent when it does that is saying if you're going to make a major change, we need to be involved with that. And maybe if you, at the very beginning of the process, restricted what the agency does, you wouldn't get the large change. And I will now finish up with the 3 areas of legislation that we came up with. First is, at the very beginning of the process, we think it would help to allow a public comment period. So when an agency starts to draft a regulation, before it's given it to the Department of Administration, require it to put online, this is what we're doing. We're amending this regulation to do this. Legislators, public, now's your time to get your input in early at the very beginning of the process so we can consider it before we even give it to the Department of Administration. I don't think that would delay the process any because it takes time to draft a regulation and get it right. A second idea, and this is used in many other states, is somehow the legislature is able to designate certain regulations as expedited, meaning we want this one done now. It goes to the top of everybody's list. It doesn't have to wait, and it gets priority over everything else. Maybe it's a statute that comes out and you need the regulations to implement it. A third one, and I don't think this would have a major effect, is to make a distinction between substantive regulations, which is most of them, and small technical changes. And small technical changes would not have to go through the whole process and clog it up. They could be things like changing contact information, or in our case, we had some old 1970s regulations that said, you will write a certificate in the following format, and instead of words, it was a picture of the certificate. I don't know why that was done, but we changed that and made it words so people could cut and paste it. But little changes like that, maybe you could short circuit the long process. And so, Mr. Chair, that ends my testimony. Again, it was kind of a summary of the current status, some of the problems we've seen, and then some possible legislative and drafting solutions. And with that, I'll stand for any questions.
Okay, I told you knew what he's talking about. So, on the impact statement, the financial impact statement, you gave us some suggestions on dollar amounts. I'm assuming you meant that goes towards that. Do you have any? Is there a process by which any agency reviews the financial impact statement that's put forth by the agency that may or may not be true? I mean, we've seen some pretty zero financial impacts when it was actually tens of millions of dollars. Workers' compensation regulations came through with no financial impact, but it was really, to the industry, tens of millions of dollars. And so is there a way to check that? Who's responsible for saying, well, that's not right?
Mr. Chair, the Department of Budget should be reviewing the economic impact statement. They may be limited in their ability to fully understand the scope of a particular regulation, who it affects, how it affects it. They don't have the industry coming in saying, this economic impact statement is wrong because no one in the public has seen it until it comes out later on in the process.
So an early look at the regulation like you suggest.
I think an earlier
solve
look
that.
and more ability for the public, and by the public, it's usually not Joe and Jane average voter. It's lobbyists and trade associations are very interested in regulations from the very beginning. The people that are affected by it will want to see it and watch it, see what the words are. But, and I don't mean to accuse any agency in Kansas of playing games with the dollar amount, though I understand they can have difference of opinions. They can be different of opinions on what they should be measuring and how it should be measured.
Okay. And it seems like every bill that we do, we give the agency rules and regs authority just carte blanche. Is that something we should not be doing and only allow rules and regs in certain situations? Or if we don't put that clause in there, can they not make regulations, or do we have to say you shall not make regulations?
Mr. Chair, first, the statute must affirmatively grant the agency authority to do regulations because you're taking legislative power and giving it to an executive branch. If it's silent, there is no authority for regulations. And the legislature can narrow the scope of the authority in any way it wants. And I think sometimes with the legislative process, it's so hard hammering out a bill with everything you do that the regulation part is almost an afterthought. It's you shall write or you may write, and then the agency will get it again. And I think most agencies in good faith want to do what the legislature intends. And again, this is kind of a joking example, but if the legislature designed a house by statute and said in the agency of paint will determine the interior paint colors by regulation without any other guidance, house is built, legislature walks in and goes, who the hell picked these colors? I mean, that's kind of what the agency feels like sometimes is they want to do the right thing, but maybe their perspective was different than the legislature. And I don't know exactly how that drafting would be done, if the reviser would have a checklist to say, okay, make sure you think about this, or.
Representative Wassinger.
Thank you, Mr. Chair. And I've tried to say this to the legislature when they come up with a bill. If you're in committee and you're drawing up a bill and you're working on it, you're putting it through hearings, you should know what specifically you feel like they should be regulating. You know, you should be drawing up rules and regs on the length of time or whatever. I mean, I can't give you an example. But when we're working on a bill and everyone's gotten as nose deep into it, they should know some of the parameters they should have. They can try it and it can be tweaked, because otherwise they can do anything they want to. And I think you're being very kind to all the agencies saying, I don't think most agencies want to do overreach, but they do, and they don't care whether they do or not, and they thumb their noses at us. So it's important that every legislator understands that when you do a bill, if there's something to do with rules and regs, while you're working it, you can start getting some parameters. You may not know what all to do. It may not solve the whole problem, but you should be able to figure out where you want them to kind of concentrate on so that they can do that and you can see much better regulations drawn up, and it's not, doesn't mean that you won't ever get anything that's out of hand, but it takes more work by the legislators, and we've got to pay attention to that. I think they're all tired of me coming up and saying, you just said give them rules and regs authority. That's not good enough. We have to be able to tell them where you want them to do that. You know, if you do a, anyway, we've got to be diligent in making sure we know where we want things, what was our intent, the legislative intent. What is the legislative intent for every bill? You write down what the intent is, you'll be able to figure out where you want those rules and regs to be going. Not specifically, but giving them those parameters, I think that will help. Will that be the only thing that we can do? No. We need to have more responsibility on whether or not they can actually pass some regulations that are clearly outside of their scope. But it's really important for us as legislators to know we have to be doing the first step. Thank you, Mr. Chair.
Senator Vasco.
Thank you, Mr. Chairman. So I serve on the Joint Committee on Rules and Regulations as well, and so I somewhat concur with what the chairwoman has said. And then I want to say to Clay Barker that I know Senator Karen Tyson is just delighted to hear that online. Now you can see, the progress. Thank you. And Mr. Chairman, so my question for Clay is this. So if in the Rules and Regs Committee, so we are wherever that process you just listed, so we give the legislature gives the state agencies the authority to do X, Y, Z. Okay. So then they come before they need to implement, somewhat our intent. So then they come back, but then they see that, oh, something else needs to happen for the mechanism for it to work. Then they come back before the Joint Rules and Regs Committee, and we make recommendations. But are you saying in that chain of that process, so you said that the agency can move forward and do whatever they want because we gave them authority, and they can just keep doing it until we take it away or implement or vote again in the session. Explain that process right there again to me of where the agency has the authority or they lose it. Or they need permission again.
Right. Mr. Chair and Senator, so when the legislature enacts a statute or statutes enacted into law, it will grant the agency authority of some scope to adopt regulations. And that draft regulation will go through the process. JCAR and the public comment are fed into it, but the agency doesn't have to listen to JCAR or the public comment. They'd be fools not to listen to JCAR. I remember a regulation on there, I think it had something to do with asking for student financial aid, and the individual was questioned quite severely on that, and that regulation then went away. But once the regulation's through, the agency can amend it at any time it wants without having to go back to the legislature for new authority, or it can revoke it or repeal it. It has authority over that area. And the only way it can lose the authority is if a new law is passed, so both chambers and the governor or supermajority of both chambers takes it away. So once you've granted the authority, it's you've given some power there to the agency to act.
So we need to be intentional. Thank you, Mr. Chairman.
Yeah, Senator Tyson.
Oh, thank you, Mr. Chairman. I just want to back up the chairman and the good senator from Sedgwick, and thank you for your comments. I can give you so many examples. It would make this committee's head spin, and I'll give you a really egregious one that I felt like. We had rules and regs on whether there should be whether you agree on the issue or not, 2 trained engineers. And what happened was the previous Attorney General ruled that the governor's office did not have authority to mandate 2 engineers in the train. So lo and behold, it goes away. So they tried to bring a bill in. Well, guess what? The bill didn't move anywhere in session. Didn't go anywhere with the legislature. So a new Attorney General gets appointed to office. The governor puts in rules and regs again to require 2 engineers in the train. New Attorney General, new opinion, and guess what? They created law. So, I mean, there's been so many examples. Your office, was one of the most egregious, and you might say, well, you didn't know what the legislature was expecting. Well, you're in front of us all the time. You can just ask us. I mean, it's not that big a deal, but didn't it take I don't know, it was years. I'd hate to guess how many. Representative Carmichael would know right away. But anyhow, thank you, Mr. Chairman. It is an issue. We all agree it's an issue. I appreciate your suggestions, and I agree with the chairman. We need to take this very seriously because we are giving them legislative authority. Thank you, Mr. Chairman.
Supervisor Emmer?
Thank you, Chairman. One possibility that was suggested by Mr. Adele would be to amend the statute pertaining to fiscal notes, 753715A, just to require an agency, in addition to providing a fiscal estimate through the director of the budget, to indicate whether or not regulations would be wanted or needed, and the extent of those.
And we would know in committee, as we were drafting the bill or voting on the bill and making changes, we would know that they're looking to make rules and regulations and only around these certain items.
Yes.
It's a good idea. Representative Wassinger.
I just want to say a thank you that we are finally getting rules and regs online completely so you can see this, because for the 8 years that I've been on rules and regs, and every other year I'm chair, and I get letters in the mail from an agency that says, we are going to revoke this one, and we're going to start this one, and we're going to do, you can't find what the new regulation is going to be. You can't find any of that information. And I know that the Secretary of State came and said, we need money to do this. And I said, I agree, but it was so expensive. I said, I just can't, we just can't fit that in. They did get a grant, so that's how they're able to do it. And it makes a huge difference because, for example, the Department of Labor put in all new rules and regs. They legislated by regulation how to do workman's comp. I said, how do you do this? We can't even find it online. How do people say, yes, this is what we need to do? So this is huge. This is huge for legislators so that they can read things and they can see what's going on and where it's been. It's huge for the public so that they know what's going on. So I really appreciate your working towards that and getting that done. Thank you, Mr. Chair.
And Mr. Chair, if I might, that system, if everything works out, it's about halfway implemented. Working with agencies, should be ready April, May of 2026. Roll it out and but it's IT, I don't.
We are so, well, I'll say Karen and I, and maybe this is a good senator, I am very excited because I know that Senator Tyson also used to be chair, so she knows it's like shooting in the dark.
And you're probably aware of this. There's the only place where an agency writes down in a short paragraph, this is what we're doing, this is what these changes do, is in the economic impact statement. It has to give a short summary. Otherwise, you get this long, lined out addition words, and you're trying to figure out what is going on here. Mm-hmm. And this new system would allow that at the beginning. You get an idea what the agency's doing or what it claims to do.
I know that we required them to do an economic impact statement if it was more than $1 million in a year or $5 million in 5 years. And we still didn't get it. Wildlife and Parks, and it was 2 years ago, tried to say, we're not going to have deer season in the fall. We're going to cancel it because of chronic wasting disease. We're just not going to have it. And I look at the economic impact statement, and it was 0. And I said, really? So you're not going to lose any money for licenses? Oh, well, just licenses, that's not much. Well, you're not going to, none of the restaurants, the hotels, the gas stations, any of the people that do hunting parties, and they're not going to lose any money? I said, well, maybe some. We can't get that information. I said, you have tourism in your building, and they do it every day. Shame on you. Shame on you. Go back and figure out how much is this going to cost. It's a very difficult committee to feel like you can get anything done. Thank you, Mr. Chair.
Seems like you struck a chord there. You love the passion, don't you?
Oh, yes, Mr. Chair. It's an emotional issue, and rightfully so. It gets to the core of implementing government, the legislature's intent. It's where the rubber hits the road, I guess would be the way of putting it.
All right, any further questions or comments? Seeing none, thank you. Thanks again for everything.
Thank you, Mr. Chair.
All right, so next up, we've got, switching gears here a little bit. One of the bills that we talked about last year in Commerce had to do with home-based business regulation, and that passed out of the House, was over at the Senate for further work, and it's still kind of over there. And so we've got Taylor Walker from State Affairs Associate with Goldwater Institute on WebEx that's going to kind of give us the breakdown of that bill and what it does and why it might be needed. Taylor, are you there?
Thank you, Mr. Chairman.
Okay, good.
Can you hear me?
Yes, we can.
All right. Well, thank you, Mr. Chair, members of the committee. As he mentioned, my name is Taylor Walker, and I am the State Affairs Associate at the Goldwater Institute. We work in courtrooms, capitals, communities across this nation to protect constitutional rights. And among those issues that we cover, one of the most paramount is the right to earn a living, and this would include operating a no-impact home-based business. Now, unfortunately, many cities and towns across the states currently have outmoded zoning, licensing, and permitting requirements that impede entrepreneurial freedom to run a business from a home. And these requirements have real impacts on real people. In Springfield, Virginia, out of Fairfax County, there was a woman who ran an online clothing store from her house and was forced to shut down, and not because of neighbor complaints or safety issues, but because her locality prohibited retail activity in a residential area, even when all sales occurred online. And in Chandler, Arizona, not far from where we're based in Phoenix, Kim O'Neill ran a quiet, unobtrusive medical billing company from her home business because it enabled her to care for her sick father. But the city shut her down because her business had employees, even though they didn't work in the house. Unfortunately, these stories are only the tip of the iceberg. So I would encourage this committee to use this next session to quickly ensure that no impact home-based businesses are protected against overregulation. And I think we can all agree that local officials should have those tools that they need to target nuisances and ensure that buildings are safe. However, homeowners should also have the ability to operate no-impact home-based businesses without having to endure lengthy, uncertain, expensive licensing or permitting processes. Individuals should not be penalized for simply working from their home instead of a traditional office, especially as our ever advancing technology allows for more innovative pathways at our very fingertips. So the question remains, how do we go about this? Well, by removing the requirement for a person to apply, register, or obtain localized permits, licenses, variances, or other types of prior approval, you offer a very simple path for legitimate business owners. City permit requirements for home-based businesses might have been created with great intentions, but it is so easy for them to be hijacked by not in my backyard or NIMBY neighbors. And then you have private squabbles between neighbors that develop into public disputes that involve government. And this gives our local governments an incentive to unnecessarily involve themselves in private enterprise and, worse yet, private homes. This idea would be to remove the hurdles in front of these businesses without removing those guardrails surrounding them. Now, if a business is contained entirely inside a home and has no impact on the surrounding areas, there isn't a reason for local government to place burdensome regulations on entrepreneurs. Home-based businesses provide opportunities for individuals to be their own bosses, contribute to their local economies, and generally support their families. In fact, there was an Institute for Justice survey of home-based business owners. Over 2/3 of the respondents that were surveyed said that their home-based businesses are important or very important to their household's financial security. And of those same respondents, it was also reported that it took over 2 months to satisfy their regulatory requirements needed to operate a business out of their home. And this was a nationwide survey. One-size-fits-all restrictions fail to recognize that the typical home-based business is a quiet, responsibly run operation that their neighbors never even notice. While local governments have a responsibility to protect neighborhoods against nuisances, they shouldn't use this as an excuse to impose burdensome blanket rules on home-based businesses that don't have an impact on the surrounding neighborhood. If a mom can teach her daughter to play violin in her living room, it makes no sense for the government to penalize her for teaching someone else's daughter in that same living room. If it's legal to do your own income taxes at your kitchen table, there's no reason that an accountant should have to jump through local regulatory hoops before doing someone else's taxes at his dinner table. As long as these entrepreneurs are not disrupting traffic, causing loud noises, or creating other nuisances, there's really no reason for entrepreneurs to not be free to operate a business out of their home. And as I understand it, the current model under HB 2343 carves out all of these situations where localities can legally intervene if a business steps outside the sale of lawful goods and services or generates clear nuisances. Now, this year, Texas and West Virginia decided to protect no-impact home-based businesses, and they joined several others, like Iowa, my home state of Florida, and even your neighbor, Missouri. If Kansas were to pass a bill to protect home-based businesses, you'd really be setting a precedent, an unwavering statement to your constituents that you care about small business owners, and especially to those self-starters who work out of their homes while minding their own. And on behalf of the Goldwater Institute, I would urge this committee to consider legislation that would change the status quo for home-based business owners. And I believe that is under HB 2343. Well, thank you for the opportunity to speak, and I'd gladly take any questions.
Okay, thanks for your presentation, and thanks for being here. This bill through the House, and then it's in the Senate, and it did need a few more changes because there were still a lot of questions in the House, and in order to pass it over to the Senate, I told them we would work with the Senate to make necessary changes for clarity. And I think some of the issues were parking and Airbnb type things where they didn't want it to supersede locals' authority to regulate Airbnbs and things like that that might be disruptive. Can you tell me what some of your largest objections have been and how you've addressed them in other states?
I'm trying to think of some of the other objections. Thank you, Mr. Chair. So Airbnb has been one of the bigger objections, but as I understand it, I don't believe the bill covers or allows for Airbnbs to be operated out of homes, as I understand it.
It doesn't. It doesn't, but it doesn't specifically say that. So we were going to make that change to make sure that everybody was on the same page. But yeah, go ahead. I'm sorry.
No, of course. If you think the clarity is necessary, then of course I would encourage you to clarify it. I know that was also something that we discussed based on HOAs and their ability to govern. As I understand it, the bill has adapted those changes as well for HOAs. I think HOAs were the primary concern for the other states.
Representative Clayton.
Thank you. Thank you for giving testimony to our committee today. I saw in your testimony you mentioned problems in other states and the reason for that. Can you give me some specific Kansas issues regarding these home-based businesses? Because I'm seeing stuff about Virginia and Arizona. I don't care about them. I care about Kansas. Can you tell me about Kansas things? Thank you.
Of course. Thank you so much, Representative. I wanted to refer to my colleague Tanner, who is also on the call. I believe he's slated to speak after me for Kansas-related issues. But as I understand it, as I've done my research, it appears that Kansas has localized licenses that would provide barriers for a lot of home-based businesses to operate. And you can research that from city to city. Kansas City has them, Liberal Kansas has them. It's a very cursory search that you can find those barriers that act in place of home-based businesses.
No, and I've seen the barriers because I've seen the list in the other testimony. I want to hear about specific businesses that were forced to close or downsize because of these. So I know what the regulations are. I want to see where the direct problem is for specific businesses. Do you have anything like that?
So as I understand it, I recall a couple that spoke in the same committee earlier in January, no, excuse me, February. And I could be happy to pull their name and send that to you. I just can't recall it. I remember they testified though.
Oh, she's on the committee, so we can pull up the video and show it to her. One of the regulations that we talked about was the city of Topeka here requires you to have a license to sell something on eBay, which is burdensome. And that's the kind of thing, the little things that we were trying to address with that bill. It shouldn't have been anything major, but it seems like every time we do a bill that's simple in nature, it gets blown way out of proportion, and people come up with pretty drastic examples of things that aren't really covered by the bill. And then people run with that narrative, and then that kills the bill because people believe it. Rather than taking the time to address it and hash it all out and make sure that everybody understands it, we just kind of jump to conclusions, and then one person after another talks about the same talking point that's not real. And so we need to work on that a little bit better next year. Any further questions? Representative Wassinger.
Thank you, Mr. Chair. Do you have an exact definition for no impact businesses?
Yes, I do. That is defined within the bill. Let me actually pull it for you. So a business is defined if they, excuse me, hold on. Yes, a no impact means that a home-based business is encompassed of on-site employees and clients don't exceed municipal occupancy. Your property and business activities or character.
We're having some trouble hearing you, so she has his bill, and it's right there.
We're having some bandwidth issues here. Maybe if you turned your camera off, we could hear you better.
Can you hear me now?
Yes.
Can you hear me now? Okay. All right. So yes, business activities are limited to lawful sales of goods and services. They don't generate on-street parking or increases in traffic throughout the residential areas. They occur inside the residential dwellings and aren't visible from the street.
Okay, thank you, Mr. Chair. Thank you very much for your answer.
Okay, any further questions for the Comfrey? Oh, I'm sorry, Senator Dietrich.
Thank you, Mr. Chair, and I was going to say this for Tanner, but so it doesn't really matter who answers it. Who defines nuisance? Anybody can answer it. Do you know who would be responsible for defining nuisance? Because what's a nuisance?
As I understand.
Oh, I'm sorry, go ahead.
Excuse me, I'm sorry. Thank you so much. As I understand it, nuisance is defined in criminal law, is it not?
I do not know. I'm not an attorney.
Charles, would you be able to answer
Charles?
that on
Is it?
the definition of nuisance?
Thank you, Chairman. So I believe there may be some statutes on that. I was in the process of trying to find it, but it's also would be defined in case law. There would be cases, probably a fair number of cases where property owners have filed suit based on claiming that there's a nuisance, and so that would be something that the courts have looked at.
May I do a follow-up then?
Go ahead.
Thank you. Thank you for that, Charles. So then I guess my question would be, if it's defined in statute, it's criminal, if my HOA is, I've lived in the same house for 24 years and it's the same HOA, what would be the appeal process? If I said, I think you're being a nuisance, my neighbor, just hypothetically, and we're in the same neighborhood, same HOA, do I have to file criminal charges for that? Or do I'm getting, there's a little bit of fuzziness here. I just wanted to understand a little bit better.
So it's possible, Senator, it's possible that there would be a criminal provision. I'll have to check about that. But where I was going really would be more the civil claim.
But still, it would take court action?
Yeah, it would still be probably a court action, yeah.
Okay, okay. Thank you, thank you.
Representative Shute.
Thank you, Mr. Chair. This also might be a Charles question, but you can answer if you want. Am I reading section 4 of the bill right in that it says the city cannot require a license for any home-based business or no impact business? So like, even though they are businesses, a city can't require a business license in section 4?
Supervisor Reimer.
Thank you, Chairman. So the language of Section 4, which you can see on page 2 of the bill, probably about in the middle of the bill there, states that the municipality cannot prohibit a home-based business or otherwise require a person to obtain any permit, license, variance, or other type of prior approval from the municipality to operate the business. So that's pretty straightforward language that indicates that with respect to the municipality, the municipality cannot prohibit or require a license.
So if a municipality does currently have some sort of blanket license for all business, and I don't know if they do or not, then they can't do that for home-based business based on this language.
So, yeah, I guess there would be some angles to answering that. You know, one would be whether the effective home rule, but basically, yeah, if there would be there's no grandfathering provision that I recall that's in this bill. So if it would be in violation of the state law if the bill passed.
I can't speak for the people that brought the bill, but the way I looked at that was they couldn't create a license because it was a home-based business. To license home-based businesses, maybe it needs to be worded differently, but if it's a business that requires a license, I would imagine they still had to have the license, but yeah, that's a tweak, probably. Good catch, though, Representative. Any other comment? Representative Clayton, did you have something to say?
My question was, again, more of a Charles question. So basically, as we read this bill, does it allow, we talked about homes associations yesterday and how they were able to kind of have certain restrictions. Does this allow, I mean, for instance, if we pass this and you know, the cities aren't able to have these regulations, aren't HOAs just able to put in whatever they want to and it basically makes it redundant, or how would that work?
Thank you, Chairman. So the answer to that can be found on page 2 of the bill in section 3. If you look at sort of the top part of that page, there's a provision there that specifically pertains to that the home-based business is to be a permitted use, and it supersedes any homeowners association, covenant restricting the use of land on or after July 1st, 2025. And then there was an amendment that was added by the House Committee that provided an exception that the permitted use would not supersede bylaws of a homeowners association if there is a clear, directly applicable restriction in the homeowners association bylaws and a reasonable likelihood that the business activities of the no-impact home-based business or rural no-impact home-based business are likely not to be consistently compliant with the requirements of the Act. So that exception was added. But otherwise, the use would supersede homeowners association covenants if that covenant is entered into by the business on or after July 1st, 2025.
All right, seeing no further questions, we'll move on. Thank you very much for being here today, and thanks for your testimony, and thanks for clarifications. And we're now down to Tanner Temple. Welcome to the committee, sir.
Not as tall as Clay, so I got to move the mic down a little bit. Kind of wanted to start, I overheard some of the questions, specifically on why we're doing this in the first place. If you look at, for example, Representative Clayton, you mentioned how to relate this to a Kansas-related issue. On page 2, Prairie Village, for example, if you think of an Amazon worker that a lot of these people are outsourcing to, basically Uber drivers of Amazon drivers, in Prairie Village, they wouldn't be able to deliver between 7 a.m. through 9 p.m. It wouldn't include sales to people that weren't invited to a home-based business, only one customer at a time. And your district is not as bad as something like Topeka. Topeka, you need a license to even get to sell something on eBay or a Facebook Marketplace. So one of my wife's favorite pastimes is to get on Facebook Marketplace and sell stuff. So if we lived in Topeka, we would have to get a license to even get something moving in Topeka. The Home-Based Business and Fairness Act is designed to protect the right of Kansans to run a business from their home as long as they're not harming their neighbors or community. So there is provisions in here that would not oversee what we've discussed about HOAs and fire codes. It empowers people who need flexible ways to earn a living, like parents, veterans, people with disabilities, and those in rural areas, while still keeping local governments in charge of health, safety, and nuisance prevention. Cities will still be able to enforce fire codes, again, noise codes, and other safety standards. The bill is very similar to what we've seen in Florida and Texas, and where similar laws have worked without disrupting neighborhoods. Again, importantly, the bill does not allow businesses to disrupt neighborhoods. So we're not promoting to have someone put a used car lot in their front house or their backyard. That's not the things we're trying to go after. It does not remove the local authority to address real problems. It does not exempt anyone from safety or tax laws. The home-based businesses must still follow all state and federal rules. It also does not permit retail storefronts or large-scale operations in residential areas. Again, this bill matters because home-based businesses are a vital part of the economy, especially as we've looked after COVID-19, the expansion of internet sales. I mean, a lot of these businesses are internet sales there prior to the COVID-19. Even when I was working in the corporate world, I was working from my basement there for a long period of time. So there is people moving self-made products, things out of their garage and using their garage space as a home-based business. Again, we've seen how important flexibility is by bringing predictability and preventing outdated or overly strict local rules from stifling innovation. This bill helps Kansans invest in their future with confidence. And last year, I saw an example from Eric Stafford. He mentioned, companies like Apple starting in their garage, and Microsoft, and a lot of these companies that started in their garage and started from a grassroots type business thing. Those are the people we want to protect and make sure they're not running into red tape as they get things up and going. But again, I'll stand up here for questions.
Representative Clayton.
Thank you, Mr. Chair, and thank you for being here. Obviously have noted that the 3 cities of which I am honored to represent parts of, all have restrictions, but here's the thing, and I wasn't aware that I'm supposed to go and look up previous testimony. I would think that if you had signed up to come and provide testimony today, you would have specific examples of how the cities of Overland Park, Leawood, Prairie Village, or Topeka or other areas, specific businesses that were stifled or were forced to close. That's what I'm looking for, not these cities have regulations, but because of what Overland Park, Prairie Village, or Leawood did, these people are suffering economically. That's the kind of evidence that I'm really looking for. And do you have anything offhand that you're able to tell us about?
Again, when I started, I mentioned the Amazon businesses. So, I mean, they used to have the big blue vans driving down the street. And now if you look up, I see in my Ring doorbell a lot of times the Amazon delivery guy pulling up in a, 2012 Honda Civic, dropping off some stuff on my front porch. So those people would be considered a home-based business according to a lot of these stipulations again, and Prairie Village, Topeka, in those areas. So those are the people that it would affect, the internet sales especially.
I see Amazon trucks all the time in my district. No one has come to us and is saying, oh, no, I can't do this. So That seems more like a generalization. Any other specific examples of businesses that are being stifled? Because if we are causing economic harm to people by allowing these regulations, I want to know about it. I'm just hearing general things. And plus, like we want to be like California now. That's a new deal to me, guys. But, that's generalized startups from the 80s. I want like more specific stuff.
I think you've made your point, Representative. Senator Owens.
Thank you for being here, and thanks for you being here, Tanner, as well as the gal from the Goldwater Institute. Sometimes the legislature takes a purely reactive approach to legislation, right? And oftentimes that's what catches us behind the 8 ball with things. This is a great example of something that we can do that is proactive, that ensures that businesses that are no impact to our communities, people that want to have a business, can do so, and that we can encourage entrepreneurship from people in their homes to grow and take care of their family. I'm just a huge believer in everybody having some kind of a side hustle. And, are we going to regulate the DoorDasher next and make them get a license because they're driving their car around delivering McDonald's? Amazon has gone to a lot of those private contractors. Yeah, there's a lot of Amazon trucks out there, no doubt. But a lot of these private contractors are just folks trying to make a few extra bucks to make ends meet to pay their property taxes and their insurance. So I just wanted to appreciate your proactive approach to this legislation. Thank you.
Representative Turk.
Thank you, Mr. Chair. I had a unique, back and forth with a constituent of mine. He was trying to open up an FFL. It's a small business. He tried to do the right thing. He tried to go to the city and make sure he was all on the up and up with them, and the city blatantly told him no. Lucky for him, FFLs aren't regulated at the local level. As he went through the process, he learned that was an unnecessary step, and lucky for him, he got to open up his business. But hypothetically speaking here, if we're just talking about an Amazon or a Walmart, they're small contractors. They're contracted to drop ship out of their garage oftentimes. Hypothetically speaking, if you're that individual, that's your job, that's how you pay the bills, and you go to the city and like, hey, I want to be on the up and up with this. The city says, no, we don't allow it. However, it's still the one thing that pays your bills. What's the likelihood that that person just continues to do it and waits to get caught? All right, you essentially are forcing them underground so that they can pay their bills. Thank you, Senator Owens. I agree with you. It's a proactive mindset, and it's very rare in this building. So I want to just put that hypothetical out there to the committee to consider and think about. And again, thank you for your presentation.
Senator Alley.
Thank you, Mr. Chair. Tanner, could you tell us under what you're proposing, what would be prohibited? What type of home-based business would not be allowed?
Yep, so anything that affects health and safety. So, I mean, you're not going to open a home-based, a chiropractor shop in your garage or something of those natures. So anything that would violate local fire codes, anything that would violate health and safety, those things would not be allowed again. And there is noise ordinance in there too. So, I mean, you're not going to be running a rental equipment, running big bobcats out of your front driveway. So things of that nature. It does keep in mind that it will not overrule local HOAs or anything of that nature.
One of the concerns that has been brought up and was brought up last year when we discussed this was service-based businesses. And the one I'm thinking about would be a dog grooming business. What would be the restriction for that type of business?
Well, I mean, if it doesn't affect health and safety, I mean, in theory, it would be allowed, but I don't want to, that's something I'll have to get back to you on, to be completely honest.
And then we'll go back to a cosmetologist. opening a hair salon in their spare bedroom.
Are you reading the bill?
I am. I want to ask a question.
Again, long as it's not violating any health or safety standards, then in theory would be allowed.
Thank you.
Representative, or Senator Owens, and then Representative Wassinger.
Thank you, and I'm glad you mentioned dog groomers, because I want to tell you a little bit of story about a dog groomer. Because she happens to be my daughter, by the way. She happened to, single mom, started grooming dogs in her garage, right? Bought the little table off of Amazon, self-taught, started grooming dogs at a very discounted price with her garage door open. People saw she was grooming dogs. She had more people stop by. Facebook helped her grow her business. Then as a single mom, went on to buy a small grooming business that wanted to sell right there in Heston, Kansas. So that business that started as a no-impact home business with no licensing requirement in her garage in Heston, Kansas, with really zero regulation by the city, county, or state, has grown into a thriving little business where she has one full-time, one part-time employee, is charging sales tax, paying payroll tax, and really, in her own little way, benefiting the state. That's what I see this as, right? That's what I see this as, a step into entrepreneurship that same thing kind of with the sandbox regulations that we did, right? How can we help people prove that minimum viable product and then help them move into actually becoming those employers that we need in our state? So thanks for mentioning that. I hadn't even put that together, but you mentioned a dog groomer, and it's just a really great example of entrepreneurship working out of somebody's home.
For clarification, now that she has an employee in a bigger business, she's no longer working out of the garage, right?
That is correct. She's got a storefront in Heston, right off the interstate. Pays rent, pays taxes, all the good stuff. It's great.
Representative Wassinger.
You know, I noticed that a lot of these don't allow people in the garage. Senator Dietrich gave me an example of someone that probably shouldn't have done their business in a garage because it was engines and lots of people coming back and forth. They were doing lawnmowers and all sorts of things. But I mean, I'm looking and it even says, you can't be in the garage in Topeka, which there's more problems with Topeka I don't want to get into, but it says, Hayes, you can't use your garage. I have 2 people right off the bat that I know have businesses in their garages. And they're not high-impact businesses, so it's not a nuisance business. So I think with this, it says if it's high impact or nuisance, and getting a good definition of nuisance from the law would be the stopgap for these home-based businesses, and people could continue to do it. Telling people they can't do things in their garage is like, you can't walk on the right-hand side of the street. You can only walk on the left-hand side of the street. Anyway, thank you, Mr. Chair.
Representative Turk.
Thank you, Mr. Chair. So in defense of the cities, Tanner, in this, can the cities continue to regulate traffic and the roadway, right? So say as this business grows, as this dog groomer grew and traffic became an issue, the city still has a say in that, right?
That is correct. Yep.
Thank you.
All right. Any other, Senator Klemp?
Thank you, Mr. Chair. And when this stalled in the Senate, do you recall what was the issue or issues that resulted in that? And I would think that if someone is doing repair work in a garage with flammables, it probably wouldn't be allowed or shouldn't be allowed. So there's probably some rules around small engine repair and other things that would keep that from being a business. There's probably a lot in towns that do that probably shouldn't be. But I was just curious on the first question.
Yeah, absolutely. And that was some of the things discussed, like where does it end, like motors and things of that nature. And that's what we try to address during that committee. We talked about noise ordinance and health and safety laws. So I think that was one of the things that got it tabled. And again, it is tabled in the Senate Commerce Committee currently.
There's still work to be done on that bill, and we'll work with the Senate on what the House concerns were that we promised we would attempt to change before we brought it back from conference committee. And so there's a lot of work to be done on this bill, and there's a lot of clarification and a lot of explanation to be done on the bill, and hopefully we'll get there this year. All right, sir, thanks for taking the time to review this with us and bring it back up before the start of the session so that we might be able to help these small businesses going forward.
Yes, sir. Thank you, Mr. Chairman.
All right. We're scheduled for a briefing from Charles Reimer on that bill, but we've kind of gone through what the bill does and doesn't do. So we're going to go ahead and give Charles the afternoon off on that one. Next up, we've got licensing and regulations considerations for women-owned business from Wendy Doyle at United We, and they were one of the people that were excited about the bill for the Sunset Bill, Sunrise Bill, I guess, that ended up being Senate Bill 30 that's in the Senate right now. Go ahead. Thank you. Thanks for joining us today, and thanks for, this isn't your first time in front of a committee. At least you've been in Commerce Committee a couple times, so we appreciate your input.
Thank you, Mr. Chairman, members of the committee, and as Representative Tarwater mentioned, I am Wendy Doyle, President and CEO of United We. We're going to break it up a little bit. We've got a few slides this afternoon, and that will pop up on screen here. While that's coming up, thank you again for the opportunity to speak today about the need for occupational licensing reform. What our data reveals about key challenges and opportunities, the importance of enacting SB 30, and the positive outcomes Kansas can expect as a result. And as the slides are trying to pop up, I'll just keep continuing. United We, just by brief background, is a nonpartisan, nonprofit think and do tank, and our North Star is really advancing women's labor force participation and civic leadership. As of September 2025, the labor force participation rate for women in the United States was 56.9%. Though a more recent report for October shows an increase of 57.5%, and women make up about 47% of the total labor force across the country. Our mission is super simple but powerful. We remove barriers that prevent women from fully participating in the workforce, whether that be as an entrepreneur or in the workplace, because we know that when women are working, they're contributing to the Kansas economy. We use evidence-based research to identify what holds women back and establish partnerships to translate findings into real solutions. United We has the privilege of working with Kansas policymakers like all of you to advance meaningful reforms such as licensing reciprocity, reforms in the cosmetology industry, and licensing compacts we've been supportive of. The reviser did an excellent job of talking about what SB 30 does, so I'd like to focus my comments today on the research that gave rise to our introduction of this legislation last year and how this common sense licensing reform is anticipated to increase participation in the workforce and boost our Kansas economy. Occupational licensing has expanded from impacting just 5% of the workforce in the year 1950 to roughly 26% today. While Kansas, as mentioned by Clay, is among the least licensed states, barriers still exist, especially for women re-entering the workforce or relocating with families. Workers who hold licenses are less likely to move across the state lines, which limits labor mobility and slows business growth. So we want to keep them licensed in Kansas. Over time, duplicative or outdated regulations have created friction that affects small business owners and entrepreneurs the most. You heard about this earlier today with the briefing on HB 2343. Modernizing licensing is about balance, protecting public health and safety, while ensuring qualified Kansans can get to work quickly. There was a link in my written testimony to our Status of Women in Kansas research report, which uncovered several hard truths. Women earn a median salary of $38,000 compared with $49,000 for men, a gap of about $11,000. Women dominate in caring professions that tend to pay less, while men are more represented in managerial and technical roles. Kansas has the largest gender gap in self-employment, 11% of men versus 7% of women. Women are 6.5% more likely than men to hold a certification or license, which means inefficient licensing systems disproportionately affect Kansas women. These realities make licensing reform a critical lever for improving women's economic opportunity and overall workforce strength. So we're on data-driven solutions. There you go. SB 30 is a common-sense, data-driven approach to make Kansas licensing systems more transparent, efficient, and fair, as you've heard today. It prevents duplicative boards, ensuring new licensing requirements are necessary, and promotes portability across state lines. The bill keeps public health and safety at the forefront while preventing barriers that serve no real purpose. It reflects compromise language developed collaborative among key stakeholders last session. This reform positions Kansas as a model, as a leader across the country for practical bipartisan governance that supports both workers and employers. Next slide. Licensed workers earn roughly 1/3 more than unlicensed peers, but burdensome processes can delay that opportunity. Data shows that engaging more women in the workforce could grow the Kansas economy by as much as 15%. Streamlining licenses helps fulfill workforce shortages, strengthen small businesses, and expand entrepreneurship. So we want to try to change that metric and get a little closer to the national average. When we remove unnecessary red tape, we help Kansas use their skills productively and keep our economy competitive. So occupational licensing reform is an investment in talent, and Kansas has plenty of it. Next slide. As you heard this morning from the Kansas Chamber, licensure compacts are the gold standard for improving portability while maintaining state control and practice standards. Nationally, there are 17 professions that now operate under or developing compacts, including nursing, counseling, cosmetology, teaching, and social work, as an example. Expanding Kansas participation sends a clear message. Skilled professionals are welcome here. And living in Kansas and contributing to the economy, just like the senator outlined with his daughter and the pet grooming business, is essential. This policy enhances workforce mobility, supports rural service delivery, and meets critical needs in healthcare and education. Embracing compacts modernizes Kansas' regulatory framework without compromising safety or quality. Next slide. Our research is clear. Occupational licensing reform is essential to unlocking women's economic full potential and fostering entrepreneurship. We firmly believe, and in the enactment at SB 30 will carry with it several advantages and advantageous outcomes for Kansas. It will streamline process, reduce unnecessary bureaucracy, and expand workforce participation, fueling economic growth. Not only will these advantages be realized, I think we all agree occupational licensing is an issue worth studying. You heard Eric mention this morning that we are unsure of the number of occupational licenses. So SB 30 presents a unique opportunity for us to gather the data necessary to make informed decisions when discussing future occupational licensing reforms. I want to sincerely thank the committee for the opportunity to share our perspective on this important issue for the state's workforce. United We stands ready to continue working alongside you in advancing common sense solutions that move our state forward. Mr. Chairman, I'm happy to answer any questions.
Yeah, thanks for the information, and appreciate all the statistics in here. And while you're here to advocate for women and women-owned businesses, these
applies
subjects
to everybody.
All Kansans are affected
All
by this
Kansans,
stuff. So.
correct.
Senator Clem.
Thank you, Mr. Chair, and thank you, Ms. Doyle. I had a couple of questions. One is I fully support kind of workforce participation, especially for women, and trying to, what you were saying was resonating. So, but the other topic I have is one of the things we're trying to do in Kansas is grow our base, grow the number of people in our state. When we make through compacts and through some of the things we've been talking about, when we allow for that transferability to be more streamlined, do we feel our state is competitive enough to where we're going to gain employees, or are we going to lose employees because across the river is a more competitive tax environment, and they might sit over there and handle telemed in our state of Kansas? Just wanted to maybe get your perspective.
Senator, it's a great question. My perspective is that it is a retention strategy to keep the worker in Kansas by having the compact so that they don't have to move across state lines to be able to do their work.
Thank you. I wonder if whether we can get some data on what we think has happened, because we have compacts today that we have implemented for a series of years. I wonder if we're seeing a increase in those areas
in retention or moving across the state line because Kansas has the compacts in place.
Yeah, it might be worth looking at that data to see if we haven't done that already. So thank you.
Thank you. It's a great point.
Okay, so KLRD, can you work on that? Get that for the committee? And just get with Senator Klemp after the meeting to make sure he's getting exactly what he's looking for. Eric?
Sure. KLRD is responsible for reporting annually on the expedited licensure data, which also, it involves people coming into the state. And so we, in those reports, I believe there may be some relevant information. So I can forward those to the committee after the meeting, and then I can follow up with you just to see if there's anything additional that you'd like.
Thank you. Representative Clayton.
Thank you, Mr. Chair, and thank you for being here, Wendy. We're not going to have time to completely change the world, but I do want to point out that a lot of that workforce participation language, that would be the paid workforce. Women do plenty of unpaid labor that supports our workers at home, that allows the family to run, that allows these workers to go to their jobs. Someone's making the lunch and doing the laundry and not getting paid. So I would argue that anyone who lifts a finger anywhere in any household is a worker. Sad that they're not getting paid for it, but we can't change that instantly, although you guys really should think about it more. What I want to ask is, when it comes to these fields regarding occupational licensing, does United We do any research that covers any specific fields that women are looking at where those specific license barriers do exist for them? Are we seeing it more in cosmetology? Are we seeing it more in, any sort of home-based business? Like, what are we looking at? Where are those fault lines?
It's a great question. And just to share, we are embarking on a significant 2-year research study on occupational licensing. And so we will be able to come back to you with a lot more detail. This research study is an investment by the Ewing Marion Kauffman Foundation. We'll be doing a national scan broadly, but more specifically looking at the state of Kansas on this very issue on specific occupations, but really getting granular about the barriers of re-entry or moving across the state line, or what that may look like. So I'd like to put a pin in that, be able to come back and report. But, just broadly, cosmetology has been something that United We has worked on with you to kind of chip away at some barriers. Example of the eyebrow threading was one specific example to deregulate that in Kansas. But cosmetology seems to be a more feminine occupation, which a lot of women are employed. So it does rise to the top.
Yeah, well, I'm not going to get my eyebrows threaded by some dude, so I totally get it, yeah.
All right, so moving right along. Licensing in Kansas. Are we licensing professions in Kansas that other states are not, that you're aware of?
No. What's great is Kansas, as we cited, and as Clay, one of the most unlicensed state in the country, which is not a bad thing. So good governance by Kansas, a real leader.
Okay, good. That's good news. All right, any further questions? All right, seeing none. Thanks for coming in.
Thank you.
All right, Robert Hutchison, Deputy Attorney General with the Attorney General's Office, is here to talk about an update on the regulation sandboxes legislation that we passed and what they may or may not need from us going forward.
Thank you, Mr. Chair. I appreciate you inviting me to come out here and give you an update on this important law. I can tell you what we've done and what needs to happen for us to do more. What we have done since the law passed is looked at what other states are already doing, especially Utah, Arizona, Florida, and North Carolina, who, like Kansas, have a broad spectrum regulatory sandbox rather than specific industries like other states. And we're looking at their application processes, their criteria, how their advisory boards meet and review and pass along information, as well as how they post the information to the public. Applicants, admitted companies, expected risks. So we've begun looking at that to begin drafting our own applications and our own internal processes, as well as any possible regulations that might be needed. I think that would be limited to some definitions. The idea of innovation or innovative offering is important in the sandbox bill, but is undefined. And I think it would be important to provide some parameters there, but we would not be looking to add big regulations to a law that's designed to reduce that impact on new businesses. So we've begun that process of drafting the application, as well as looking at what any kind of policies or procedures or regulations might need to happen to facilitate that. That's largely where we are, because unfortunately, with the lack of an omnibus bill this past session, the 1.5 FTEs that were identified in the statute were not funded. So the director for the Office of the Regulatory Sandbox and the administrative support portion of it are unfunded for now. Our Chief of Staff, Michelle Schroeder, has engaged with, I know at least Senate leadership, but I believe House leadership as well, to have that taken care of in an early supplement next session. But we want to be able to make sure we have the infrastructure in place and the concepts in place for that, once that's funded, to get the program off and running. So that is our current plan, what the ideas that we've built up and the drafts that are in place, so that as soon as we actually can be operational with it, we can get this rolling for the state of Kansas.
Okay, so the things that you're asking for, you would rather not do through regulations of your own. You want the legislature to do them, and you have a bill coming to us to clean it up.
No, ideally with regulations, I would only provide some definitions to provide clarity to applicants. I don't think we need any additional legislation or process regulation, and I'd like to avoid additional law on this thing that's supposed to make life and business more efficient for folks. I think we can do it through the application process and procedures, and at most some definitional regulations. The legislative action that would be helpful would be funding the 1.5 FTEs that were identified in the bill to allow the program to operate.
Got it. Okay, cool. Any questions? Senator Klemp.
Thank you, Mr. Chair. And just for my own edification, on the FTEs you're looking to hire, do they have a business background or something that can help with innovation? Or how do we think that your group is going to help with innovation, and is that going to be found in the FTEs?
Yeah, I think a business, and hopefully a business and law background, would be ideal for that director spot. Someone who has an established engagement with the private sector, but also is close to the regulation side. Someone who can help identify the regulations that should be peeled back, and also effectively engage with the state agencies who do have some say in what regulations would be waived during the sandbox period.
It's just to layer on top, just seeing a position description would be helpful. I think it sounds great, and I appreciate the question. Thank you, Mr. Chair.
I would be happy to put one together. That's not something I've gotten to yet for those, just because we don't. I've got others that we're posting for the agency within the division, but I'm happy to get something together to help, and any feedback would be appreciated, certainly.
Yeah, the identifying of regulations that need to be repealed or should be repealed or are most punitive that's my favorite part of that whole bill. And so I think I agree with you on that. It's important to get the right person in there that understands it. We talk about regulations up here all the time, and we're overburdensome, and we've got pages and pages and pages and millions of words or whatever the talking point is on it. But nobody has ever come, and I've asked many times, bring me a list of regulations and we will get rid of them. And no one has been able to do that. And I think that this bill in this office is going to be able to identify those for us, or at least quite a few of them. And so I'm really looking forward to this. And I agree we need to fund it if we need to fund it. So.
And if I can, Mr. Chair, one component that I'm also working on that is in the portion of the bill that talks about identifying regulations that can be stripped back, it talks about establishing a risk analysis framework for the potential harms to the public of rolling back some of those regulations that on initial review could potentially be identified as removable. Not a lot of entities are open to sharing that kind of a thing. So I'm working to build one of those. It's more my MBA background than my JD background that will come into use there. But we don't want that to sit on the back burner, because I agree that's an important part of the sandbox also, is not just helping individual applicants, but also the regulated business environment for Kansas as a whole. So we want to make sure that that can get moving as quickly as possible too.
All right, seeing no further questions, thanks for the update, and we'll get you funded.
Thank you, Mr. Chair.
Mm-hmm. Okay, moving on. Richard Watson is here with the State Fire Marshal's office and Chief Deputy Secretary, or Chief Deputy. Boy, well, I almost thinking Hoheisel. Chief Deputy for the State Fire Marshal, Richard Watson. And I wanted to give the State Fire Marshal's office an opportunity to kind of present some of the difficulties they're having with regulations. We've talked about it a little bit earlier. Clay brought, or one of the conferees earlier, brought up the fact that the State Fire Marshal is trying to consolidate a lot of these regulations. And a lot of times the locals have different regulations, and somehow the State Fire Marshal's office is the one that takes the blames for them. And so I wanted to give them an opportunity to explain where they are in the process and how things are going and what we could do to help. And so thank you for coming in today. And I know that, we just talked about this maybe 2 days ago at the most, and I really appreciate the fact you're coming in, and the committee needs to know that it may not be a complete presentation because he had no time to work on this. I just kind of put him on the spot, but thanks for doing this. Yeah.
That's green.
Yep.
Okay. Our end goal is to reduce the deaths, injuries, and property losses of Kansans. We work directly with building owners and facility managers every day to find solutions within our statutory and regulatory limitations. We are focused on providing consistent and professional inspections. We do so utilizing a statewide fire prevention code, which was first established over 50 years ago. This code this code has uniform force and effect throughout the state and sets the minimum fire safety standards for all places where people work, live, or gather for any purpose, with one exemption: 1 and 2 family dwellings. The fire prevention code we are currently using was last amended in 2011, but is largely made up of code versions released from around the 2006 timeframe. This is the sole fire safety code for around 95% of the state. As Mr. Chairman identified, there are some of the bigger cities and more populous areas that have adopted newer code. They do that through our office in a review process. The rest of the state falls under that bare minimum set in 2006. That is the table. Those more enhanced codes in the bigger cities, larger populous areas, they can make it more restrictive, but they cannot take away from that tabletop. They cannot go below that level. And sometimes that is a challenge for us, and I'll get into the whys here in a little bit. The current national consensus standards were last updated in 2024. So to provide some context, and I stole this from the boss, the cell phones that most of us are using when the current fire prevention code we have adopted right now, most of us were using flip phones. Okay, now I get it that flip phones are kind of making a little bit of a comeback, but understand that the technology in today's current flip phone mimics much of what most of us wear on our hip or have on our desk right in front of us right now. The 2006 version of the International Fire Code that we are utilizing today is the oldest in the country. Everybody else has stepped up except for the state of Kansas. New versions of these national codes include new technologies, construction materials, methods, and alternatives developed by engineers and architects. So when you hear us say prescriptive versus performance, if it's prescriptive, it's in the book, it's in the code, it's in the standard, and that's what you must go by. A lot of the newer codes, as we progress through the years, allow us to perform what we call performance evaluations, that we can look at something and say it does the same thing or better in a different format. Right now, we're very limited on adopting a lot of those performance capabilities just because of the antiquated language in our current fire code. These advancements allow the same engineers and architects, as well as designers, builders, facility owners, the opportunity to incorporate the latest technologies into new construction and renovations of their buildings, which did not exist in 2006. These national consensus standards are updated approximately every 3 years. They are vetted by leaders, professionals, and just the people that make it go zoom in their respective industries and disciplines. And they have been successfully defended in court time and time again. I know that gets a lot of folks' attention. If we adopt something new, what's that going to look like when somebody tries to sue, which society being what it is today, we do have to look at that. Over the last 2 years, our office has been very open during legislative testimony directed at the problems we are facing with the rules and regulations process. Our state codes need to be updated to reflect the current national consensus standards, the rules and regulation process, which allows agencies such as ours the functionality to functionally apply directives provided in the statutes developed and enacted by you and your colleagues. While the current rules and regulations process may work well for simple rules, regs, amendments, we found it is not well designed for the approval and adoption of codes, some of which are more than 1,500 pages long. They are, think about the old Encyclopedia Britannica, thick, and that's what we're looking at. There seems to be some misconception and fear that newer codes versions bring new requirements and restrictions to existing buildings. However, in all cases, that is just not true, okay? And it's not uncommon for additional costs to be incurred while this new construction or these renovations are forced to go back down to the 2006 code. That's where money and time is spent, and a lot of frustration is garnered in the process. Our office was 3 years into the process of adopting the 2018 standard when the rules and regulations process was changed, requiring us to develop and submit an economic impact statement. This change not only affected the fire prevention code, but also that of our boiler, propane, and elevator safety programs. If we're talking about something as simple as changing the fee that an agency charges for services they provide, that's easy. It's extremely difficult to provide the legislature with accurate information when applying major code changes. Additionally, small agencies such as ours, we're neither trained nor staffed to conduct the complex economic impact studies that are required of us. We would, however, fully expect any type of economic impact study to come back and show that over that 5-year time period, $1 million is nothing. It's a drop in the bucket when it comes to renovations, new construction, anything to do with that, and that as well of elevators. Doing so would also require the legislature to craft and ratify a bill to approve one particular regulation or code for that particular situation. So we're always looking for ways to streamline our operations, make them more user-friendly, despite sometimes what you may hear. We are trying to work with our stakeholders and our partners. We're currently working on a state fire code based on the 2024 version of the International Fire Code. We currently also have more than 25 different updates and amendments in some stages of the rules and regulation development process or updating process, some of which directly address concerns about our office that have been brought to the legislature by stakeholder groups. The current path forward is slow. It's frustrating, especially when changes are needed quickly to resolve conflicts between the regulations and the statutes, or simply to react to rapidly changing workplace conditions. It's 2025. You turn your head and something new has popped up around the corner, whether it's in the fire alarm system or if it's in a communication device that's inside of an elevator. That technology is rapidly evolving, and if we don't embrace it, we're just going to get left farther behind. So one example is the state of Florida. They've put a process in place that they've identified the National Fire Prevention Code that they will follow and allow their fire marshal's office to automatically adopt the state fire code every 3 years to the newest standard. This would allow us to keep pace with the ever-changing advancements, reduce additional fiscal expenditures, and reduce many of the frustrations that a lot of us encounter. Short, sweet, and to the point. I thank you for your time once again, and I will stand for any questions that you may have.
Senator Dietrich.
Thank you, Mr. Chair. Thank you for being here. I feel your pain. I do. I mean, I've heard this before, and I appreciate all that you do. When you say Florida's process, did I hear you say allows them to automatically adopt the national standards every 3 years?
Every 3 years with a caveat, ma'am.
What is that?
They have their own committee within the state of Florida that involves their building officials from, representatives from across the state, fire, life safety officials, stakeholder officials, building code officials. So it's just not an automatic, all right, it's dropped and it's new, it's in force. They look at it for what's best for them. Are there certain parameters or certain conditions that maybe they need to take a look at and either develop a variance or an exemption for whatever it may be? And it does work well for them. Yes, ma'am.
And may I ask a follow-up? So let's say you have that kind of a broad-based group that looks at those standards, works with the fire marshal, makes those changes automatically every 3 years. What is the legislature's role in that? Do they have a role in that? Do you know?
That's a good question. I would simply say, it's in the rules and regulations allowing us that latitude. I'd have to come back with you with a little bit more research to how would those pieces integrate into your process, and would be happy to provide a response back to you.
I mean, I do see that is very cumbersome.
Yes,
Your
ma'am.
codes are, massive, and they're very hard to update, and our process probably doesn't help you with that. So how can we be less of an obstructionist for their business, I guess, too, would be the question. Thank you.
Yes, ma'am. Thank you.
Yeah, so I guess our role would be to look at and consider a law similar to Florida's. At least research it. That would be our role. Once we pass that, though, it would be in their hands, and it would supersede the other laws that we made recently that would require economic impact statements and give us a say on some of the regulations. Would you be able to, if we allowed that kind of board to look at it every 3 years, would you be able to then bring to the legislature the new code for us to weigh in on? Would that be too cumbersome?
I wouldn't think so, but then again, I don't want to speak for the state fire marshal with him not guiding, giving me a little bit of guidance there. But at the risk, as Ms. Dietrich identified, maintaining that cumbersome approach, we look at it and we go, okay, and then we send you 3 massive three-ring binders, and everybody has to weed through that. Again, we have to figure out a little bit about what does that look like when the rubber finally meets the road. So I'll get that back to you. And my apologies for not having an answer for those.
Well, we wouldn't expect you to have all or any of the answers in one day that I gave you to put this together. So, yeah, one of the things we talked about yesterday was the cost of housing, and when there were several instances this year where the new code is causing increased construction costs on, I think, fourplexes or bigger, where previously may not have required fire suppression systems, but now we are. Maybe it's three units.
3 or more, yes.
But it was because we've always had that regulation, it just wasn't enforced or something along those lines. That's what we're trying to avoid is, we want to drive down the cost of housing safely and maybe come up with different solutions for fire spreading from one unit to another rather than having an expensive fire suppression system.
That is exactly true. And for the committee, and I don't mean to get graphic, but everything that is written in either one of the International Code Council, whether it's fire code, building code, or if you go over to the National Fire Protection Association side of the house, which is a comparative, a lot of times NFPA is a little bit more restrictive. A lot of that code was written in blood. It's because somebody did die, because lives were lost or somebody was significantly or seriously injured. You know, and we don't like throwing it out like that, but at the end of the day, that's what it really is. But as Mr. Chairman identified, sometimes there's more than one way to rope that horse. If we can look at different options that do keep housing, costs, because we know that they, just as he identified, they're on the rise every day. So we're trying to find the best and safest path forward for everybody involved.
Senator Clem.
Thank you, Mr. Chair. Just curious, when you have a discrepancy or how a local fire marshal interprets a rule, what is that process? And I only ask that because in the first city of Kansas, we have a historic district that is not being developed due to rules. And you probably hear that in a lot of different areas. So that being said, when as a developer, we don't choose to develop that because the numbers will never work the way they sit today with the rules that are required. Is there a interpretation and a softening that can be guided by the legislature to provide guidance to interpret things in a softer way that's still legal to allow, since we have buildings since 1843, that we've never had a fire? But I'm just curious, what's that process look like, and how would we maybe soften some things to allow some development to happen or to occur?
So again, going back to some of the things that I identified during my presentation, the newer codes, for one, are a lot less restrictive. They're able to look at a lot of the building construction that's going on, some of the things that Mr. Chairman identified, possibly building in a form or fashion one way would take away the need for something else that is more cost-driven or cost-impeding. So I think just the simple language in the new code answers a lot of, will just answer a lot of your questions straight out of the gate. When it comes down to, so if we still cannot find a happy medium or that interpretation is still off, we do have a process in place that goes through, because we do look at it, and not to belabor the point, so they send us their recommended code that they're wanting to go to. We look at it and make sure that it doesn't fall below the minimum. And where there are discrepancies there, then we start some of the negotiation back and forth. Can you do this? Can you do that? And then it comes down to a hearing with the State Fire Marshal's office, with our attorney from the Attorney General's office. We don't like to go there. Because that just adds to the process and adds to the frustration. But short answer is, I think you would see a lot less restrictions in the new code just because of what we've learned over the years, being able to apply certain surface preps, using different materials that, yes, it didn't burn in all those years. Good for them. Does that answer your question, Senator?
Yeah, I think it could. A lot of these are just sanding floors and getting the old building in shape, where now you're required to have a sprinkler or something that's significant. But it's, let's just start with the new code and see if that does alleviate some of the challenges. So I appreciate it.
Yes, sir. Thank you.
Representative Wassinger.
Thank you, Mr. Chair. You say it's simpler, but is there any problem with existing businesses having to come up to the 2025, 26 code, is there something that they have to retrofit? I'm just wondering about the expense in that area and trying to figure out how you deal with that and whether you grandfather in.
So the answer that we provide in a lot of cases, and everybody hates to hear this, is one word: depends. It depends a lot. A lot of it is what we call a 50-50. So if they're modifying or renovating 50% or more of the structure itself, or 50% of the value, that's where it kicks into the new. And that's just the way that it's written. They have to come up to full new code requirements. If they stay below that, then there's the international existing building code. We can dial a lot of those into our code to find, again, some leeway in there. How do we work with, our customers, essentially, to get where they need to be? So there are rules that weave in and out, and it gets a little hairy and a little frustrating sometimes. I get it. But again, there are codes and rules in place that keep them out of having to go to a new full code requirement to the newest standard.
All right, thank you. So if I redid 40% of my business, I would do the lesser codes, but if the very next year I did another 40% and then maybe a couple of years later did the last 20%, would it still apply, or would you be looking at it? I'm a troublemaker, I'm sorry.
So we would be looking at that because we keep records on those facilities. So yes, when we saw that come up, a lot of us have memories like old elephants. And we would see that and we're like, let's go back and take a look at this. And again, it's not so much to pin somebody down to the floor and say, hey, you have to do this. It's an education approach, the why.
Right.
A lot of times if we can explain the why, and sometimes it's in a worst case scenario type situation, if we can explain the why, a lot of times that alleviates a lot of that concern.
Okay, thank you very much, sir.
Thank you, ma'am.
Thank you, Mr. Chair.
Yeah, and I can add that I've worked with this fire marshal on several different occasions, and he is very business sensitive. And when things cost too much, he looks for alternative ways and gives variances, and he's very pro business, and it's enlightening to work with him. So if you ever have a question or a concern from a constituent or somebody, call him and he'll work with them. It's pretty incredible to watch. So it's not something we're really used to. So let's see, we had Representative King.
Thank you, Mr. Chair. Quick question for you. Is it difficult to write a state fire code when there's different IBC, UBC codes different cities have implemented? Or I guess I'll just leave it at that. Is it hard to write using different codes?
So, no, it's not hard to write it. It's just getting everybody on board saying we're going to this code, this version. A lot of, again, our bigger cities where, as you're mentioning, they've already adopted, they're already on board. We've already looked at their code and made whatever adjustments with them as needed. And we're able to go forth and just they do what they do. Where we've run into the biggest issue are in the 95%. The folks that are outside of your larger metropolitan populous areas, where it's one of those, they just don't think the code applies to them because nobody's ever enforced it, as Mr. Chairman identified. Nobody's ever enforced that. So no, it's not hard to write, and everybody's on board. We need to get to a newer code. That's one of the things that when we go to chiefs meetings, regional fire marshals meetings, that's the first thing they hit us with right between the eyes is, when are you going to get the new code up and going? We're trying. It's a process. So no, it's not hard to write, and it's just getting everybody at the table on the same page, and we'll go.
Senator Alley and then Tyson.
Thank you, Mr. Chair. And I think going on with Representative King's comments, some of our smaller towns, smaller jurisdictions are not up to the latest code. They're up at, I think, 2006 perhaps. When you adopt the code, how does that affect the local jurisdiction?
So much like it is now, our 2006 code is it's in full uniform effect across the state, so it would apply to them as well. Part of the issue, and if you've heard Mr. Ingholm, State Fire Marshal, speak before, a lot of the issues we run into there are folks that don't know the code. They're trying to inspect based on that code, which we're working with our KU partners to fix that situation. But again, short answer is that applies to them. And much like, you know, if there's a concern or a question, all they have to do is call us, and we'll help them figure out the answers as they're going through that process. We have a lot of folks in our office that, you know, are inspectors or they're code reviewers. They know these rules and these standards inside out. It's not to make life more difficult necessarily. I realize sometimes it does unintentionally, but it's trying to, again, provide a safe work and living environment for everybody in the state without a lot of cost as much as we can. But then again, it does cost.
Do you find that the 24 code that you're adopting now is more restrictive than the 2006 code?
No, sir. Not even in the least. There's, again, the technologies that we've seen advance, the building materials that we have seen come around in simply the last 10, 15 years, let alone nearly, 50 years, just is phenomenal. So it is a lot less restrictive, allows us a lot more, again, latitude to do what needs to be done for the best of the customer.
Thank you very much for being here.
Thank you.
Senator Tyson.
Thank you, Mr. Chairman, and I would echo the chairman's comments that the Fire Marshal's office has been very responsive and helpful in situations. I have a concern, though. What code are you planning to adopt? And I brought it up earlier in committee. Coincidentally, rules and regulations, they tried to adopt new codes, and it would have mandated all new single and multi-family, two-family homes to have sprinkler systems. And that was a major burden. The builders were very upset about it, and it was cost prohibitive in a lot of areas in Kansas. I mean, I understand we've got to weigh security and safety versus cost, but it's a reality.
Sure.
So would that be one of the mandates? I'm just cautious about some of the regulations that we would be adopting.
Sure. And so much like we said in a situation right now, the current statute says that we cannot require, the state cannot require anybody to install those sprinklers in their homes. It's been in various code revisions since it was first introduced. If that is the will and pleasure of the legislature to maintain that position, then so be it. That's where we're going to go, and that's where we're going to stay. As a former firefighter, as a fire inspector, as an assistant chief of prevention, I have seen sprinklers work well in saving lives and affecting that exit and that getting out of the house when it's on fire. I will live by that every day. But if that's where the legislator wants to stay, then that's where we'll go with it. Does that answer your question, ma'am?
I'm just concerned that if we say, yes, adopt new codes, we're not going to know the details of what's in those codes until we start getting calls from our constituents, is what I'm afraid of. So, no, it didn't really.
So if I may, Mr. Chairman. So again, going back to if we went to the automatic with provisions, what would that process look like? We would certainly identify, from straight out of the gate, anything that changes drastically, like sprinklers in single-family and two-family dwellings. That would be something we're going to bring up. We're not going to try to sneak it out, and try to just bring it right in. We're going to be very transparent, very upfront. Hey, this is what the old code said. This is what the new code said. This is a stark difference, and we would present that as well, just so you have eyes on it. It's very, we're not trying to hide anything, ma'am.
So unless we change that statute that disallows sprinkler systems in single-family and dual homes, you wouldn't be able to do anything with that anyway.
Unless that statute was repealed and removed, correct. Otherwise, it stands.
Okay. And then if we find other things in the new code that we wanted to add to that statute, we could do so.
Absolutely.
So, okay. Is that something your office is putting together right now, a comparison between 2006 and 2024 that you'd be able to circulate?
It's very much a work in progress right now. I cannot give you a percentage on where it's at in its process, but we're working at it and looking at it right now. So first chance we get, certainly we would be able to share our information.
Okay. I bet there's been other states that have probably done that we could learn from and cut down some of the time on that, but that's your call.
Right.
Representative King.
Thank you, Mr. Chair. Just a statement here. I was able to attend one of the regional meetings with the State Fire Marshal and would echo your comments that a very positive experience with the current State Fire Marshal. One of the things that's come up is the technology at the State Fire Marshal's office and the plans that the architects and the design build contractors are giving. It's a little antiquated, so I would encourage the State Fire Marshal's office to really think about the input, the technology, and to improve your technology to be able to accept plans and reviews in a much more expedient manner, and then also look at the use of AI in plan review. Thank you, Mr. Chair.
If I may, Mr. Chair. So Representative King, we are currently looking at a couple different, I don't want to say fully automated. It's a cloud-based system that would allow those architects and designers to submit, because that's one of our concerns from an IT perspective is we get these files in a PDF format, at least that's what it says when the email comes in. And if we've all been affected by it at some level at some point. So we're looking at a couple different cloud-based solutions right now. I dealt with one when I was working with the U.S. government not that long ago, where it allows you as a designer, for instance, to come in, you submit those to me, our staff looks at it, puts our comments, it puts it right up into the cloud, and it's a very, very quick system. I think at least one of them, if not both that I know that we're looking at, have AI components. We're not trying to buck technology, but we're also very cautious when we start looking at that kind of thing. So we are looking at that, yes. We've been listening to our customers, our architects, our engineers. They've said the same thing, and we're trying. Thank you.
Okay, I'm not seeing any further questions. Thanks again. I think this is productive. Thanks for coming today.
Thank you, Mr. Chair. Committee, thank you.
All right, so anybody have anything else? Speak now or forever hold your peace. We'll move on to preliminary discussion on today's meeting. And if you have anything left over from yesterday that you want to throw out there, you can do so too. So Senator Owens.
Thank you, Mr. Chair. The only one that comes to mind is just a recommendation that we bring back to the table the home-based business that's currently sitting in Senate Commerce that is tabled, and take a relook at that, work with the House to come up with whatever fixes are needed to pass a good set of legislation. Thank you.
Yeah, and I've had some discussion with some of the opponents on that bill that would be happy to sit down with the membership on all the players that are involved to kind of work through some of the questions and concerns that they have that might already be addressed in the bill, but just need some clarification. And I think they're willing to work with us, and then once we have them behind the bill, I think it'll be much easier for all of us. And I don't think we're going to have to change much, really, other than clarification. And so does anybody have an objection with recommending that we look at that bill next year? I'm seeing none. Any other recommendations or thoughts from today?
Nope, I was just going to say I like the fact that
Senator Clayton?
Sorry about that, Mr. Chair. Very pleased to hear that the opponents and proponents will be sitting down and just working on some of the differences. I think that's the way some of our best legislation gets made, so I commend that.
Representative Hoheisler.
Thank you, Mr. Chair. I just wanted to give you one more opportunity before we dismiss today. Would it be wise for the committee to recommend to the 2026 legislature the funding of the 1.5 FTEs for the regulatory sandbox?
Yes, it would be. Yep. Any objection? Seeing none. Any other recommendations from today? The Secretary of State's suggestions, I think we should look at those next year. Is there any objection to doing that? Seeing none. Anything else from today or yesterday? Senator Dietrich.
I would just like to do a little bit more research on what the fire marshal, had hinted at with the Florida legislation and just see what kind of a process they have in place that wouldn't remove the legislature, because I hear we need to play a role in that, but it needs to be, these codes need to be expedited a little bit more quickly, I think. And I love the idea of a crosswalk between this is what's currently in our codes, this is what the new code will be, and what are the significant differences. I mean, that would be so helpful, wouldn't it?
Yeah,
Just
so
say yes.
like maybe suggesting some sort of a task force to look at that Florida law and,
I don't know if we need a
legislative task force,
Perhaps.
something along those lines. Either way, just as a general recommendation that we should take a look at the Florida law and kind of how things work and see if we can give the fire marshal more flexibility. I think would be, you're good with that?
Without releasing legislative oversight, yes.
Right.
Yes.
Okay, any objection to making that recommendation? All right, seeing none. Representative Wassinger.
I wonder if we could make sure that we try to get SB 30 moving early in the session so we're not dragging that through and getting something done.
Yes.
So I would suggest that.
That we may need to make that one change, and I've been informed by Revisor Reimer that it's just a matter of sending it back to committee.
Okay.
And then once we make any change, we would have to start back in the House and pass it again.
Okay.
Start the process over. So
Wonderful.
we've got some clarification on that.
Thank you. Thank you,
And
Mr.
any
Chair.
objection to that? Okay, seeing none on that. I would point out on the Secretary of State's transparency, the website thing, it was discussed after the fact that it's simply, all it can do is, because it's back and forth between the divisions, all it's going to do is say this license or this regulation is being offered by this agency, without a whole lot of detail or back and forth, unless we pass some of those laws that they were suggesting. Then you can have a lot more on it without a CORA request. And so that was part of that first recommendation I made. Senator Tyson.
Thank you, Mr. Chairman. The committee might want to be aware that Kansas Legislative Research has quite a bit of that information. If you go out there, Jill Shelley puts together a form. So I don't know if it's duplicate effort there going on, but we should take a look at that to be more efficient.
In regards to which recommendation?
The rules and regs.
Oh.
Yeah, she puts a very extensive spreadsheet together.
Eric? You look like you want to say something.
Just in regard to that, we do have, I know Jill keeps information about that process. Yeah, we had shared additional data previously about some general statistics and trends in regulation over time, accumulation and like growth and those kinds of things. And so we have some of that information that we could put together as well.
Does that include regulations that are currently in the works, like the website would, or statute?
At this point, I mean, there would have to be some more work to kind of gather that, but at this point, it's a kind of a snapshot of the published version of the regs, so not necessarily what's going through the process. But as Senator Tyson mentioned, that we have Jill Shelley, and she tracks a lot of the information about the regulations as they're going through the process, so we can follow up with her and see what she has available.
All right, Senator Tyson, did you have any more comment on that?
No, thank you, Mr. Chairman.
Any other ideas or recommendations? Eric, did you have something else? You look like you want to say something again.
Yeah, sorry about that. Not a recommendation, please don't take this as my recommendation, but a couple of things that were mentioned earlier this morning by conferees that you might consider. The testimony from David Fye, he had mentioned that there were some, there's some clarification potentially related to the definition of licensee for purposes of background checks. They said that they thought they could handle it through regulations, but that statute clarification could be helpful. And then there were also, I believe some committee members had mentioned considering legislation related to licensing of contractors.
Anybody want to make those recommendations? Look at the licensure of contractors as a state function rather than local, so Holheisler.
Snuck another one in.
All right, so any objection to that? I've seen none. And then the KBI is going to have some suggested language to help clean up the regulation. Is it regulations that we're talking about? Licensure? Yeah. And so we probably ought to look at those, make sure that whatever committee ends up with those, we'll recommend that they look at them. Okay, no objection to that. Let's see, anything else? I think that covers about all of today. Did we leave anything off of yesterday that we kind of, at the end of the day, we passed over some testimony? So, nope, nothing. Okay. All right. Senator Ali?
Your agenda. You sent that preliminary agenda out.
I have not yet.
Okay.
We're still working on details for that.
I think we still have a couple of details to put in place tomorrow on that Monday agenda, but we will be in a different room on Monday because there's another committee meeting in here, and that room number is
582N.
582N. So we'll see you there, and we're adjourned for today. Thank you.